with Mr. Borsch starting his argument, that's fine. I'll handle it. But again, the agreement was for her to
Ma'am, I'm sorry to interrupt, but
Vamos allá, vamos allá,
What agreement?
vamos a poner la corte. Vamos a poner la
you
corte y después hablamos.
you filed, I'm sorry, maybe I'm confused, but you filed the motion under your name 7 months ago, 6 months ago. We prepared the case for a hearing. You conducted, I think you conducted the bulk of the hearing. You did the cross-examination of the sole witness that took the witness stand. You did the argument on everything that was done yesterday. I don't recall an agreement that we would wait for Ms. Descalso to be ready for her argument on this case. I asked you to be back here at 10 o'clock. It's going to give you all a period of argument so that we can focus on the issues in this matter. And now we have somebody who, we're moving forward.
Your Honor, if I may respond.
You certainly can respond, ma'am.
Maybe I could alleviate your confusion. When I say the agreement, that is the entire purpose of having a team. The agreement, I mean, our agreement as a defense team. That's why we have a team. Yes, I filed in May. Yes, I presented the witness. However, our agreement, the defense agreement, was for her to handle the argument. That's what I meant, Your Honor. And that's why we asked, because she does have a federal matter, if we could start at 11 a.m. Again, I understand the court's position and we can move forward.
Yes.
Thank you.
Just to clarify, yes, I told you yesterday when we left, we would reconvene at 10 and go forward in this manner. At 8:40 last night, you sent me an email asking to delay this until 11. I waited until 6:15 this morning to send you back a response from my desk saying, no, we will start at 10. And I waited 20 minutes as a courtesy because Ms. Descalso needed to cover another hearing somewhere, and she's in the jury room doing that by way of Zoom.
Your Honor, one thing before we begin, is the Zoom open? I do have a clerk waiting to
Yeah,
come up.
the Zoom is, and in fact, I didn't, thank you for reminding me. I needed to let you guys know this, that we are conducting a Zoom exactly as we would any other day in this courtroom because we do Zoom. We have 140 participants at this point, but my JA is in charge of who can be seen, who can be heard, and who can chat. And as I understand it, I hope that we be able to control that now so that the ability to chat, show video, or be heard can only be done if my JA authorizes that as a co-host. Is that okay with everybody?
Yes, Judge.
I don't have an objection to that.
Okay. All right. And so your paralegal or whomever you'd want to come in should be able to enter just as any other member of the public can.
Thank you, Your Honor.
All righty. So let me pull.
Esto se calentó. ¡Ey! Esto se calienta hoy. Estáis compartiendo, muchachos.
Housekeeping matters, maybe we can address.
Sure, I'm happy to do whatever we can to fill up our time.
Judge, yesterday, the state had marked for identification 1D. It is a flash drive that contains grades and test results for Derek Rosa, as well as his pediatric records that were provided by the defense. They are certified. Yesterday, we had some conversation regarding whether the court was going to mark these as confidential. So I just need to formally move them into evidence. And I suppose if the defense has any argument as to whether or not they should be sealed.
Signed an order with regard to some confidentiality yesterday. Ms. Tyroff, can you find that and see if it's in the most current portions?
Judge, was it done through the portal?
I beg your pardon?
Was it done through the portal?
No,
No.
it's done here in court. Well, that's what I'm looking for. Okay, got it. All right, so I'll hear from the defense. There's a suggestion that the pediatric records of Mr. Rosa are, for some reason, have been put at issue, are being presented as part of a determination, but y'all want them closed
Aguante ahora.
or sealed.
Esto viene
That's
bueno,
what I'm hearing.
Yes, Your Honor.
And the grounds for that, please?
Trata y comparte, caballero. Vamos a compartir, vamos a compartir.
In that information, there are also, to the extent that Dr. Sperry's deposition mentions the pediatric records, I would submit to the court, as we did yesterday, that some of the information and testimony derives from those records, and some of her opinions derives from those records. That's why there's that portion of her deposition was deemed confidential.
Yeah, we're going to address the confidentiality of that later on as well, because I'm still unclear as to what provisions under the law would require, now that it's been come to issue and being presented at issue by the defense, as to why that would need to be confidential. But I'll address that with you afterwards. The pediatric records, if there's something specific that you think is not relevant to this case that should be sealed in some fashion, I'll allow you to mark up the records, give me a copy in that fashion to show me what privilege you have, do it with a privilege log so that I can determine what would be appropriately privileged and what not. I'll do that analysis, and then the document will be part of the court record. And I thought about this after yesterday. It's sort of like, you put it at issue. You've made his state of mind at the time of the Mirandas an issue in this case. So why would the records that you asked me to look at for that issue not be open? So, all right. I'm asking for a privilege log and any indications within the pediatric records that you believe appropriately privileged and shouldn't be made public. What else did you want to deal with, Mr. Moore?
And just for the record, we haven't formally entered into evidence. I don't think we have an evidence number for it yet.
Okay.
No, it's gonna be.
Any objection, Ms. Riella?
Okay.
Thank you.
That's gonna be State's Exhibit 1B marked for ID will become State's Exhibit number 4.
And that sort of takes us to the Dr. Sperry's depositions. There are 2 volumes, Your Honor. As we discussed yesterday, the state is not opposing the defense's request to rely on the transcript of the 2 depositions conducted of Dr. Sperry. However, as part of that agreement, the state did make some redactions. The transcript was provided to the defense. They're reviewing it. The materials that were redacted are not relevant in the state's view as to the court's decision in the motion to suppress, which was why they were redacted and they contain sensitive information. But
Right, that would be accurate with regard to the motion to suppress. We'll address their relevance in a moment. My understanding is the portion on Dr. Sperry's deposition of November 19, 2025, that you might want to have redacted.
the December one.
I'm sorry. Let me take a look at the December one then. Stand by. Page does that commence on? Do you remember? Through, oh, here we go. Through approximately 1:15.
So about, there's some portions that are redacted up to page 125, and then there's one paragraph towards the end.
Okay. All right, I'll deal with that at a subsequent time. All right, we'll make that redacted version of deposition 1 and deposition 2 a part of the record, because that's taking the place apparently by defense request of any live testimony from Dr. Sperry. And what else would you like to cover, sir?
Your Honor, should the clerk mark the deposition transcript so they can be formally moved in?
I guess it would be a defense exhibit, if that's okay with you, Ms. Riello. Thank you.
Okay. So this will be defense A3 marked for ID will become defense C.
What else, Mr. Borst?
As far as housekeeping, that's it, and I'm ready to argue whenever the court's ready.
Separately or together?
Do you want to separate it together?
Together?
Ms. Riello, could I ask you to check with Ms. Scalzo if she has a better estimate of when she might be available for us? Thank you. Do that.
You know, the relaxed couple.
No.
Okay.
I have copies. We'll proceed. Mr. Borst, I'll hear your argument. Ms. Riello, you can make what argument you wish on this motion.
Thank you.
But I do note it's been well pled. Both sides have presented substantial case law and guidance to the court on how to do this. I will have some specific questions to you when I hear your argument. But the idea here is for the parties to place whatever focus you would like on specific portions of the evidence so the court can make an appropriate determination. Mr. Borst, you may argue.
Yes, Judge. And as the court already mentioned, the state did file a response to the defense's motion. It was filed October 29th, 2025. And in the response, I do cite to a number of cases for the proposition that the defendant's statement should be admitted, that his waiver of his rights were made voluntarily, they were made knowingly, and they were made intelligently. And I think everyone's in agreement that the controlling case here is Ramirez. Ramirez sets forth the factors that govern whether or not a defendant's statement and defendant's waiver of rights are in fact voluntary, intelligent, and knowing. So first, I wanted to sort of review the facts that were presented to the court yesterday. Also review some of the evidence that was submitted that was not necessarily published, highlighting what in the evidence is most relevant for the court and that should guide the court into a decision to uphold the confession in this case. Your Honor, the state did submit to the court for review BWC of Officer Gutierrez. And the video of Officer Gutierrez is relevant for the following reasons. First, It shows that the defendant was given privacy in the backseat of his car for a significant period of time. He was not threatened. He was not forced to do anything. There was no pressure applied to him. He was made comfortable in the backseat of a police car while he waited for police to figure out what was going on. He had some time to cool down from the experience that had occurred inside the apartment. And I think Your Honor would acknowledge that the way in which he presented on the 911 call, which was somewhat more emotional, somewhat more impacted by what had occurred. During this period of time, he had a cooling off window and he did calm down. And we see that change in his conduct, in his behavior, in his demeanor, in his tone from the 911 call to the statement itself. So I presume that the defense may argue that him waiting in the police car was somehow coercive or inappropriate. I would argue the opposite. It gave him some time to reflect on what had just occurred, make some decisions for himself. And that's why the video of Officer Gutierrez showing the defendant in the backseat of the car is relevant, because he is calmly sitting there. He is not panicked. He is not crying. He is not asking for anyone. He's not asking for anything. He's sitting calmly in the backseat of a patrol car while police try to figure out what occurred. We then see that the defendant is brought to the holding cell at the station. Your Honor can see that the station is quiet. It's a controlled environment. There are not that many people in the station itself. I feel like there's a handful of people in the entire station that the defendant comes across. It is not overly stimulative. He is completely private in a juvenile holding cell with no adult inmates, with no juvenile inmates. He is private and he's on video the entire time. And Your Honor can see that he's waiting, sitting calmly, reflecting on, what is going on and what decisions he may make. But that also is relevant to his state of mind. The holding cell it has a toilet, so it's not as if he couldn't use the restroom if he wanted to. And as was testified, he never asked police for anything that they didn't provide to him. The video then shows Derek Rosa being moved from the holding cell to the room for questioning. And again, Your Honor can see that there was no improper police conduct at all. He was treated well. He was treated respectfully. He was not physically harmed. He wasn't emotionally harmed by any way in which the police addressed him or handled him. Officer Gutierrez uncuffed him and released him to the custody of Detective Gutierrez and Detective Alasagi in a completely controlled...
You mean Detective Gonzalez?
Yes, Judge. Gonzalez and Alasagi in a completely controlled way. He was made comfortable in an office-like setting. It was well lit.
El nombre se la contó y todo.
Detective Gonzalez asked him how he was. That was the first question. How are you, Derek? Just a simple greeting. And his response was good. It was good. It wasn't, help me, I'm in distress, there's a problem here, I don't know what's happening, I want my parents, where am I? He didn't say any of that. His first statement was, I'm good. And if anything else, that should be extremely reflective of his state of mind. That although what had occurred was a horrible event, he's feeling okay. And that statement of him being good carries through the entirety of his statement. He is relaxed. He is calm. He is responsive. He provides more information than the question even calls for. All of Detective Gonzalez's questions are completely open-ended. They do not suggest him to say anything. The defendant's ability to recall and remember events that had just happened were then later proven through the police investigation. So the fact that the facts provided by the defendant were later proven to be true, that goes to his state of mind as well. that he has a good memory, that he has the ability to recall specific facts. He was not stuttering. He was not rocking. He was not making any body movements or having any body language that were indicative of a problem. He was in good physical health. He was in good physical condition. The fact of the matter is that if you look at a cold transcript of the defendant, you would have no idea he's a 13-year-old. You could think he's a 50-year-old. There's nothing about what he has to say that would suggest that he is 13. And that goes to his maturity. So yes, the elephant in the room is he had just turned 13 years old. And the court and the case law mandate that we all stop and look at all of the circumstances before making a decision about whether or not a confession is admissible. And that's appropriate, and that's what we're doing. But it's a totality of the circumstances. If it was a litmus test that a 13-year-old can never waive their rights, well, then we wouldn't be here. The case law stands for the proposition that a 13-year-old can waive their rights under certain circumstances where this state can prove by a preponderance of the evidence. It's not beyond a reasonable doubt. It's not clear and convincing. It's preponderance of the evidence that he understood and appreciated the rights that he was giving up. Another factor, and the state did present it yesterday, is the evidence of the 911 call. In the Ramirez factors, as Your Honor knows, the fact that the questioning took place in the station house, that could be a factor weighing against the state and for the defendant. But once again, I would argue the opposite. This is not a case where detectives were investigating somebody for having committed a homicide. Then they came to the conclusion that Derek Rosa did it, and then they went to go get him. This entire police interaction was started by the defendant. The defendant is the one who called 911, had a whole conversation with the police operator. It was recorded in its entirety. And you could hear that he is the one that is calling for police to come to his apartment. He was summoning them to him. So the fact that he wound up at a police station house for questioning, that should not have been a surprise to Derek Rosa. He knew and invited the police to come to this emergency situation. That was his doing. The 911 call also shows that he is able to take instruction, that he is concerned for his well-being. The defense may bring to the court's attention that at one point in time, the defendant considered taking his own life. Well, we know he didn't follow through on that. If that was in fact a plan, he did not follow through on that. And he changed his mind. And by the time he's on the phone with 911, he's telling the 911 operator, are the police going to kill me? What should I do to not be killed by the police? He obviously is interested in his own safety. He's interested in his own well-being, and he's following her instructions and directions.
Say, what do I do?
I beg your pardon, could you repeat that last part?
That is not what the statute on. I would submit that the call speaks for itself.
Yes, that part was fine. It was something else I thought I heard about your comment, excuse me, ma'am, about a characterization of what an attorney in this courtroom said. That's not going to happen here. You will have complete opportunity to urge upon the court what you believe the facts are in this case, but please try and refrain from attacking counsel, both of you, everybody. Your objection is noted, ma'am. Go ahead.
Yes, Judge. In addition to the 911 call showing that the defendant was not going to harm himself and was no longer suicidal, I could point to the time of 1:24:55 in the BWC of Officer Gutierrez. This is when he is being processed at the JAG. And he's being asked questions.
Sorry, that time again, please. I thought I heard 1:24.
1:24. The
AM?
AM, yes. And this is on the
That's-
13th.
Okay, thank you.
Oh, I'm sorry. I'm reading the timestamp on it. You're right, Judge. It's 6 a.m., 6:11:25 seconds. So I apologize. I was reading the timestamp from the other thing.
Thanks.
At 6 a.m., 11 minutes, 25 seconds, when he is at the Jack, he is being questioned, right? Because at the Jack, before they're able to admit somebody, a juvenile, into the center, they need to ask some preliminary questions. And when they question him, he's asked, "Are you upset?" The answer, no. Are you depressed? No. Are you distressed? No. Did you want to kill yourself? No, not anymore. Are you depressed? Are you hopeless? No, no. Do you have any mental diagnosis, any depression, any anxiety, any history of mental health? I went a long time ago. How long? I was doing bad in school years ago. So there's really no question, because the defendant confirms it, that he was not suicidal either before going into police custody or after, because he's telling 911, asking for ways to not be harmed by the police when they come. And he's telling the Jack processing officials that he no longer wants to commit suicide.
And how to get Baker Act?
Well, if you look at the video, the Gutierrez video, it shows that it's in the abundance of caution because of the nature of the first degree murder. And because there was a statement that in the past, the recent past, he wanted to cause harm to himself. It was in the abundance of caution for him to be Baker Acted, which probably was the right decision for his benefit.
Let me call this out because I'm a little bit at a loss because nobody put on any evidence with regard to who made that decision at the Juvenile Assessment Center, or what their standards are, or whether they have any type of specific criteria before they make a determination.
So in the BWC of Officer Gutierrez, there's an interaction between him, the Jack, and then the receiving doctors or nurses at the hospital. And more or less, the implication of what is being said, as I understand it, is because he is a juvenile, because of the nature of the charges, and because this statement had been recently made, it was in the abundance of caution. That's my assessment of the interaction between the Jack individuals and the officer and Derek Rosa.
Okay.
Oh, yeah. Ms. Morales-Gillis also brought up a good point. In the arrest affidavit, there is a mention that the defendant had mentioned that he may have taken his own life. So because it's in the A form, it does make sense in the abundance of caution for him to be processed at the Baker Act.
Okay.
So switching gears to what Your Honor heard yesterday from Detective Olasigi and the video statement itself, as well as the Miranda form. The state would submit to Your Honor that Detective Olasigi went above and beyond in his attempt and efforts to make sure that Derek Rosa understood his rights. The recording begins with Detective Gonzalez reading the entire form out loud himself. And when Detective Olasigi takes the form and administers the rights to Derek Rosa, he goes one by one. He explains the procedure that's going to be used. He lets him know that if he doesn't understand anything at any point, to ask him and ask him questions that they would clarify. The demeanor of Detective Olasigi was calm. It was patient. It was slow. And Derek Rosa indicated each and every time that he understood his rights. The fact that Derek Rosa asked for clarifying questions, the defense may argue, shows that he does not have the intelligence, does not have the maturity to have waived his rights. But it's the opposite. The fact that Derek Rosa had the state of mind to know when he didn't know shows that he understood everything that he didn't ask about. Meaning he knew he didn't know the word coercion, so he asked. And they explained it to him in a way that was more digestible, more understandable, and then he agreed. He stated he didn't know the word attorney. The detective stopped. They took their time. They explained an attorney is the same as a lawyer. And Derek Rosa said, yeah, I understand. Now that you've explained it to me that way. The way in which Derek Rosa responded to the rights being administered clearly shows from the state's perspective that he understood and comprehended what was going on. He appreciated the seriousness of what was happening, and he chose to give a statement to detectives. It was his voluntary decision to provide that statement. There is nothing during the administration of those rights, nothing that would call that into question. Nothing. There's nothing abnormal being said by Derek Rosa. There's nothing unusual. His behavior isn't unusual. This is, in many ways, a normal, regular administration of Miranda rights, and the defendant indicated he understood. The statement itself, as I mentioned before, provided specific facts, specific details, included information that showed he had an accurate memory. Get to the point of the statement where he's asked, why did you kill your mom? Why did you kill your mom? And he pauses, he reflects, and I would submit to Your Honor that that pausing, that reflecting is him determining for himself what was the best thing for him to do in that moment. And he needed some time, and he maybe had to use the bathroom as well. So he said, can I tell you after I use the restroom? Again, that is evidence. Those are facts that show that Derek Rosa is not just being led astray by manipulative, ill-willed detectives. It's Derek Rosa showing that he is alert, intelligent, paying attention, cognizant of what may or may not be good for him to say. He already knows, Judge, that he confessed to killing his mom. He already knows that he told the 911 operator that I've killed my mom. The fact that he's telling Detective Velasquez and Detective Gonzalez the same thing, again, it shows his state of mind. His frame of reference is, I've already said it and I'm saying it again. But this is something, why he did it, that he was reflecting on, not sure. Goes to the bathroom, comes back, Detective Gonzalez asks a few unrelated questions, and then they get back to the same question. Why? Why did you do it? And at that point, he invokes his rights. And this is, a situation, Judge, where the defendant himself is telling you in his video statement, I understood my rights because I've invoked my rights. What better proof, what higher or greater explanation that goes to his state of mind is what he actually did. What he actually did in that interview room. He knew his rights because he invoked his rights. He said, can I have a lawyer? And so let's break down, can I have a lawyer at that point of the statement? He understands that he has a right to a lawyer because he's bringing it up. He understands that he doesn't have to answer that question about why, because he's not answering that question. He's stopping, he's pausing. And he understands that he could stop the interview at any time without a lawyer present. That is what he is telling you when he invokes his right to counsel. He's saying, I understand, and I'm stopping the interview and I want a lawyer. And I think Detective Velasquez's reaction to that also shows his professionalism and the fact that he wanted to be very clear and cautious with Derek Rosa because he was a 13-year-old. Another detective could have said, can you have a lawyer? Yeah, you can have a lawyer, but let's, why don't you answer the question asked first? Maybe another detective would have done that. Detective Olasky pumped the brakes. When he heard Derek Rosa say, can I have a lawyer? He pumped the brakes, he took time, and he said, wait. You've mentioned a lawyer. Let's break this down. Let's give you time to fully explain to me what you want to do here. And that's when he said, yeah, I want to stop the interview.
Can I ask you a couple of questions?
Sure.
Hope you don't mind.
No.
I look at Ramirez as not really the criteria for the voluntariness of a statement, but rather as whether the defendant's in custody. Do you have any question as to custody here?
No.
All right. Also, I'm trying to remember the 911 call. Doesn't the 911 operator ask Derek at some point or other, at least once, why did you kill your mother?
Yes.
I'm trying to remember what his response was to you.
It was something to the effect of, I wanted to kill. I can't quote the exact words, but my sense of it was that he wanted to kill himself and his mother. But I could not kill myself and only killed my mother.
All right. Okay. I want to shift gears with you a little bit and go to Dr. Sperry's
Yes.
deposition.
Before we do that, Judge, could I maybe comment on some of the records that I put into evidence that might dovetail?
Sure.
Okay. Because I think the pediatric records are so important here. And I want to be very clear that the court's ruling should not be a ruling, is Derek Rosa autistic to some degree, or is he not?
Are you prepared to tell me that Dr. Sperry's diagnosis is incorrect?
I am not prepared to say Dr. Sperry's diagnosis is incorrect.
Do you think that her analysis and the methods that she used to make her diagnosis of autism 1 with no intellectual disability, that she didn't use the right diagnostic tools?
No, not challenging that.
Okay. And I want to sort of get that baseline because I'm sorry, I'm keeping you from going to your pediatric records, but I think the import is that I don't have anything in this record which would indicate other than
correct.
He is autistic, and autism 1 with no intellectual disability.
So I agree with you, and I agree that Dr. Sperry employed the correct methodology and that Dr. Sperry is a qualified clinician to do such evaluation. Okay.
Then let me go further with you on this, as long as I've distracted you from your pediatric records. I could not find, although you allude to it in your second deposition, that the doctor had some opinion with regard to the effect of his autistic state on the Miranda warnings and his waiver of his Miranda rights. I could not find that opinion. Can you take me to a page number?
That's an excellent point, Judge. And that is where I was going to land when I got to the end of my argument.
Okay.
Dr. Sperry did not do an assessment for competency to waive Miranda.
I gather that.
So that's the rub here, that Dr. Sperry's relevance is a diagnosis of autism level 1 with no intellectual disability.
Should I be looking? I don't see an opinion from the doctor as to the Miranda waiver.
Correct.
All right, because I just wanted to find, I looked again closely through the depositions last night and early this morning for that.
And I was very much looking forward to crossing Dr. Sperry about the fact that she is not providing any opinion about whether or not he was competent to waive Miranda because she did not employ any of the methodology and diagnostic tools.
When you say methodology, it would seem to me that that's a 90.703 determination that any opinion that someone would try and draw out of her testimony would not have a reliable scientific basis.
I would say absolutely, yes,
Okay.
absolutely.
I'll address the defense on that.
That's absolutely right, Judge, is that although the purpose of her deposition testimony, as I see it, is for her to let the court know, I've assessed Derek Rosa. I believe that he is autistic. He is level 1, which means that he is high functioning. She doesn't like using the word high functioning because that's not the preferred terminology right now.
Currently,
But it had been for a very long time that it is something that is a high functioning individual.
okay.
And he has no intellectual deficits.
So let me ask you this overall, because I think you've pretty much told me where to look.
Explica mejor que no te entiendo.
And tell me whether this analysis is not correct. Obviously, after Colorado versus Connolly, the standards on a motion to suppress is that you need to show by a preponderance of the evidence
Correct.
that it was voluntary.
Correct.
Okay.
And knowing and intelligent.
And knowing and intelligent. There's a suggestion in BMB and Judge Altenburn's opinion, as well as JG, that there is I'm going to use the word heightened standard, or maybe an admonition from the courts that greater scrutiny should be utilized when it's a child or someone with mental health difficulties. Would you agree with that?
I think to call it a heightened burden or heightened level of review, I think the reason why that word is being used is because as part of the reviewing factors, it includes age, intelligence, and maturity. So it's kind of baked into the cake. It's baked into the cake. You need to have heightened review because a juvenile, by their very nature of being a juvenile, they are going to weigh in favor of suppression because of their age, maturity, level of education. Does that make sense? It's baked into the cake, but the standard is still preponderance.
I guess it does make sense. It's basically their admonition that the 5 standards are in Ramirez as well,
Right.
as a custody issue, that the 5 standards should be looked at more closely. But you're right. I think you're right. The age, experience, and background intelligence has a greater importance.
Correct.
With a child.
That's how I interpret that.
Okay. All right.
Can I talk a little bit more about Dr. Sperry, Judge?
If you wish.
I do.
I mean, I think I get 2 things out of Dr. Sperry. Tell me if you need to go further.
Yeah.
One, I think she has a valid opinion with regard to whether the defendant has autism and the degree to which, as she explained it through the course of her deposition, and how he copes with it and his abilities there. And second, I do not get an opinion there that could be used with regard to whether he understood his Miranda rights and gave a valid waiver.
I think what I want to emphasize here is that being on the autism spectrum is a social disorder. It is not a cognitive disorder, right? So the only import of autism here is that Derek Rosa may have difficulty socializing. And that may relate to the way in which he expresses himself, the way in which others may view him expressing himself, but it is not cognitive at all. So being autistic has no application and has no bearing on his comprehension, his level of education, his intelligence. Autism is a social disorder, and it is not a cognitive disorder. That was just sort of one fine point I wanted to put on it. And then regarding the records, the pediatric records are important, Judge, because I wanted the court to understand that Derek Rosa was under the care of doctors his entire life, meaning he was going to a pediatrician every few months as a newborn, then every few months as an adolescent, and then every year for a checkup. And you can look at the records. Developmentally, his developmental changes over time were always, never did any of the treating doctors believe that he was not developing correctly, that he was not otherwise a normally developing young man. And so I think the reason why that's important is that, yes, Dr. Sperry now, when the defendant is in custody for a first-degree murder and being seen by a defense expert, is now coming to this conclusion, and I'm not saying she's right or wrong, but the context matters, right? Context matters. And for 13 years of Derek Rosa's life, seeing medical professionals, going to Citrus Health, being screened, being evaluated by all of these medical professionals, psychologists, nobody else comes to the conclusion that Derek Rosa is autistic. And these are, Your Honor knows, Citrus Health. This is a very reputable outpatient services clinic in South Florida. They see people who have autism all the time. He was not diagnosed with autism. And so, again, the point I'm trying to make is if the defendant is autistic, it is a very close call. And you could even see in Dr. Sperry's scoring that it is just above cutoff by a few points. So if he's autistic, it is a very close call. But even if he is, it has no import as to in my view, the ultimate outcome here. Also on the same flash drive, Judge, I put his grades and his test results. I think that's very important.
You mean in his school records?
Correct.
All 156 pages of
Well,
them?
that was the defense that provided that. I only provided maybe 5 pages of documents, okay?
Mhm.
5. I provided to the court his grades at the time he was arrested, right? The first semester of school in 8th grade. And as he told detectives, he was getting A's and B's.
Doesn't, however, I really need to call you out on that. When you
What's
look at the full school records, doesn't that seem to support Dr. Sperry's concern that there may have been a misdiagnosis? If you look at his grades, starting in the first grade and throughout, there's clearly an improvement in the 4th, 5th, 6th, and 7th grades
Well,
than there
remember,
are in 2nd and 3rd grade where he was having some difficulties.
keep in mind, Judge, his grades improve when he is referred to Citrus Health for his ADHD. So the improvement of grades occurred contemporaneously with him going to Citrus, him getting some clinical attention for ADHD, and that's when he begins to improve. So we have the grades of A's and B's. He is in honors classes. If you look at the document that we put forth before the court, honors classes. But to me, the most important thing is the statewide testing results, his reading testing, okay? The results that the state put into evidence show that his reading ability in the 8th grade is above average, state average, school average. He is above average in his reading ability in all of those scores that we provided. And so I would submit to the court that the testing results that he received in the 8th grade at or around the time that he read that Miranda form out loud, that is the most compelling because it shows that he is not below average. He's not average. He's consistently above average in all of his reading and comprehension scores. So that shows and explains why Dr. Sperry not only considers him to be level 1, which is just in need of support, that he has no intellectual disability. And I would submit to you, just like Jose Rosa said, that Derek Rosa is a smart young man. He is mature. He is responsible. And he was able to read his Miranda rights. He was able to comprehend his Miranda rights. And I just want to end with 1 or 2 cases, Judge, and then I'll be finished. The state did cite to Brookings and WM. And the reason why I cited to them, Judge, Brookings is 704 Southern 2nd 576. And The reason why I believe these cases are so important, Your Honor, is it shows that Florida courts have found that even a 10-year-old with learning disabilities, if a court's review of the video evidence of the statement shows under the totality of the circumstances that the defendant comprehended the rights that he was waiving, even then the statement could be admitted and found that the state met its burden of proof to show that the waiver was made knowingly and intelligently. A 10-year-old with learning disabilities. That's the floor that I found, right? And even in that circumstance, the statement was admitted. Here we have a 13-year-old who reads above average, has no learning disabilities, may have a social disorder that requires some support, but nothing more. And looking at everything, reviewing everything, the circumstances, the case law, the state's burden of preponderance of the evidence, we feel as if we've met that burden and would ask that the court deny the defense's motion to suppress the statement.
Thank you, sir.
Thank you, Judge.
Ms. Riello, let me say you're welcome to have Ms. Descalso make the argument and you supplement it with any response or rebuttal to the argument by Mr. Borst. I will certainly open up the floor to the both of you for purposes of this argument so that you have the benefit of both counsel.
Thank you, Your Honor, and I apologize, I was late.
Abraham, let me know if you have any difficulties with someone working from the other podium, okay? Okay, very good.
Good morning again, Your Honor.
Good morning, ma'am.
I'm going to start with the undisputed facts here, okay? Derek was barely 13 years old at the time of the incident. His birthday is August 26, 2010. The incident occurred October 12, 2023. He has a previous diagnosis of ADHD. He has been diagnosed with autism. I would submit to the court that he is emotionally and cognitively immature. I think that Sperry's deposition, specifically, I'm going to point your honors to page 12, pages 147 and pages 142.
So who are you referring to, ma'am?
Dr. Sperry's deposition.
Which particular deposition?
The first deposition taken in November 19.
Thank you.
Pages 12, pages 147, pages 148 confirms the fact that earlier in his life, specifically 2018, if we look at Dr. Ferretti's records, there was that's when she believes that they missed the autism diagnosis because there is an unknown diagnosis and he's actually sent for evaluation. And that's when she believes that the autism was missed right around the time that he was 7 years old. Now, Derek told the 911 operator that he considered suicide, that he was suicidal. And I know that Your Honor asked Mr. Borst exactly what he said to the operator. And in response to, why did you kill your mom? And that is at 3:06, and he responds at 3:10. I just didn't want to be here no more. I didn't want to live. I did not want to be alive no more. My stepdad has 2 guns. He has a Glock, and then he goes into the guns. But that was his answer to that question. Now, the fact that he does not know his own address.
Can I ask you a question?
Yes, sir.
And I really don't want to interrupt because I actually agree with you on a lot of the issues here and a lot of the factors you're dealing with. But I see kind of a parallel where each time that he's asked, why did you kill your mom? By the 911 operator, he doesn't really get into why he killed his mom. And he sort of moves over into my dad has two bones. The same thing happens at the police station when he's asked, why did you kill your mom? First, I don't want to use the word distracts, but delays by saying, can I go to the bathroom now? And then when they come back to it, he actually expresses the fact that, or questions, do I have to answer that question? Which concerns me because the state's suggesting, and it does seem to show a knowledge of his ability to say, I don't want to talk about this. And a desire through the course of the evening to not talk about that specific matter. So that's why I asked Mr. Borst what his recollection was of what your client said on 911.
Your Honor, I think the submission that he didn't want to talk about the incident, I don't want to say I would dismiss it, but I would give it very little weight only because he exhaustively talks about the incident. He gives great detail about the incident.
Except for that one thing.
Except for that one thing.
Yeah.
So, I mean, I would submit either because he doesn't have an answer because he didn't do it. So he doesn't know why, because he didn't do it. That's one perhaps argument. I can't tell you why. Why can I tell you why? Because I didn't do it. That's one argument. Or the state of mind that he was in when asked that question at 11:37 or shortly after 11:31 when he calls was so compromised that he could not process that question, much like it was at 2:39 when the interview began. Those are two things to consider as to why he talks about suicide and not wanting to be on Earth anymore and doesn't directly answer that question, Your Honor.
Thank you.
Now, the fact that he doesn't, the items that he doesn't know that someone his age should know, his address, for example, the fact that he has to go outside to look at the apartment number. He doesn't not only know the address where he currently lives, he also doesn't know his father's address. He doesn't know his phone number. He doesn't know the fact that he has a signature or that he has initials. I think that's very telling, Your Honor, for somebody that's 13 years old. Now, the fact that he doesn't know what an attorney is and the explanation that is given to him is it's a lawyer. And as we heard Detective Elosegui testify, a lawyer is a lawyer. Submit to the court that's not an explanation of what a lawyer is. Now, there was testimony yesterday that he unequivocally invoked when he asked for the attorney. Right after he says that can I wait for an attorney, which is what he asks, he immediately says, well, maybe not. And then at that point, Detective Elosegui says, listen, you're talking about an attorney at this point. If you want to talk to an attorney, if you want to wait for an attorney, we're going to stop the interview. And
Sorry, maybe not?
He does say maybe not, Your Honor.
Like maybe not, he doesn't want to wait for an attorney?
Correct. It's not a direct assertion of his rights. He's wavering. He's confused.
But then what do you make of the fact that the detective says to him, if you want to have a lawyer, I can't go further with this. Do you want to terminate this interview? And your client says, yes. I mean, that just seemed to indicate a very direct question, which implicates a knowledge of his ability to do it and a desire to do it. I got your point on the, I'm not going, we're not going to have this interview unless with an attorney present, or I can't do this if you need to have an attorney present. And I've got that. I don't think it means quite the same thing in terms of a coercive nature as you do, because he's already talking without a lawyer. And the officer seems to be explaining to him cogently that they'll stop the interview. So I'm sorry to interrupt you. But please continue.
Your Honor, the fact that there is no parental figure, I think really goes to the totality of the circumstances. The fact that there was no indication that he knew that he could have a parental or guardian figure present, I think that's very important. I think the fact that the last time that he attempted to have an adult present after the incident occurred, he was denied to do that. And that happened during the 911 call when he asks if he could answer the phone and he's instructed not to answer the phone. That's the last time that he would have had contact with an adult that he lived with, that's Mr. Ramos, and he was told by the operator to not answer the phone. I think after that, well, I know the evidence shows that after that phone call by Mr. Ramos, the only other person that he could have talked to was his grandmother that was on scene, his father that was on scene, his uncle that was on scene, but there's no indication that he even knew that those individuals were on scene at all. I think his grades, Your Honor, are really not as supportive of the state's position as in terms of his intellect, as they would like it to be. And specifically what his father says about his grades. There's no personal knowledge about his grades. There's no evidence that his father even could log into the school system to see his grades. And I think when we look at all of his grades and the trajectory of the schooling, it's very evident that it's a roller coaster.
I have to disagree with you on that. I'm sorry. But I mean, in second and third grade, in first grade, he had far more absences than you would expect from a first grader, which I always think goes to the parents as opposed to the student.
I think the medical record further explains his absences, Your Honor.
And then grade 2, 22 absences, 3 in third grade. But he went from a lot of CDs, couple of Fs in second and third grade to by the time he got to seventh grade, he's in honors biology and gets an A. Language arts, he gets an A. Honors algebra, he gets a B. Finishing up the year with 5 A's and 2 B's, and but it's still 20 absences. So I have to question the statement that it's a roller coaster academically. It actually seems to be a rise in his ability to be able to function at school and to obtain the grades.
Your Honor, I submit to the court that if we look at the medical records, he was medicated and he should have remained.
I'm not so sure about that because the indications I got early in this case was that he was prescribed Focalin.
Focalin, yes, sir.
But that he wasn't taking it at school.
Focalin, Your Honor, for over a year. And that's supported by the medical records. And then Dr. Sperry also confirms in her deposition that he stopped and he should have continued. I think Dr. Sperry also answers the question as to what I understand the court doesn't agree, but as to what I categorize as the roller coaster in grades, why, what he was doing to get those grades, what he was using, what tools he was using to get those grades. And it wasn't coming from his brain. Let's just say that. Okay. So I think that.
Sorry. When I ask Siri or I ask ChatGPT, gee, what's ABC? And it tells me that you have to read it before you put it down on the paper for the teacher. So the research tools people are using now may be a little bit easier to use, but I'm not ready to say that accept that just because he uses ChatGPT or asks Siri for an answer to an algebra question, that he's diminished as a student. That's for the teachers to watch out for. He's getting A's and B's. So I'm not ready to accept that the use of AI, and it may on the long term, but I'm not ready to accept in the short term that it makes him less intelligent or less capable of understanding his Miranda rights. I did see that. I did see what she had to say. I'm not sure I go to where she does.
Right. I think that that's a broader issue. I really do, because I think that there is a huge difference in how, for example, I learned information and regurgitated it versus how somebody now knows or purports to know the information and presents to know the information. So, yes, John. So I think that to say that he was using tools to make him give an answer and we're going to dismiss that as he still had to read what the tool had to say, that's still not him figuring and rationalizing and analyzing to get to that conclusion. All he's doing is inputting what somebody else is asking him to do, asking his brain to do. Derek, analyze this and give me an answer. Well, I can't do it, so let me ask somebody else to do it. And then I'm just going to tell you, regurgitate essentially what that other tool is telling me.
And how is that different from just going back to ask the teacher, hey, I'm having problems with this question. Can you show me how to do it? And then maybe it's not the same teaching methods, but how is that different when he asks Siri to give him an answer to an algebra question? Look, we're not going to get a complete answer on this. All I'm saying is that I don't go to the very same place that Dr. Sperry does on this. And as long as, if you want to talk some more about Dr. Sperry, I'd like to, because she utilizes the diagnostic tools of speaking with the father and the grandmother to come to her conclusions about there was not an appropriate early diagnosis, okay? But we're dealing with the very same person who sat in the police car and told Detective Alosagui what a brilliant child, how intelligent, respectful, brilliant his Derek was moments before the detective walked into a room to ask him if he understood and wished to waive his Miranda rights. So I'm finding kind of a conflict there where Dr. Sperry talks about all these, I don't want to say deficiencies, but overlooking things that a parent should have seen for a potential diagnosis compared with his, I don't want to go, let's go into specifics. I mean,
I can address that and then go back to
but I mean,
kind of the flow of where I was going. But
we're going to come back to this because there's just some difficulties that I have with Dr. Sperry.
I think in discussing Jose Rosa, Your Honor, hindsight is 2020, and it's very important to highlight the fact that he is speaking on things that he doesn't know about, and it's clear by the actual records. He's not a straight student, so
But that's the point. If you're taking if you're doing an evaluative tool with a parent, and you're now telling me this is a parent who didn't have that much time with him, doesn't it undercut Dr. Sperry's reliance upon that evaluative tool?
depends what specific portion of that tool this court is referring to. So for example, if we're talking about the grades, no, it doesn't, because since it's been the father that's had to go to all these locations to actually obtain those grades. So he's seeing now the grades. He's seen now all of his kids' records since he was born. He didn't do that before. So if we're talking about that information, then no, it does not undermine it. If we're talking about information of at what age should he speak?
Yeah.
Was he delayed in speaking? I would say partially, I would agree. And if I might finish before I lose my train of thought,
Yeah.
I would say partially. However, the grandmother, she was there every step of the way. She was there for Dr. Sperry's use, and she did. So I would say the grandma is a wonderful source of information because she raised him. He lived with his grandmother up until he moved to Amelia Oaks.
So let me ask you this, because as we look through this, you have an officer who's going to go speak with a young man, okay? And should be on the lookout for any type of deficiencies in comprehension and the ability to waive Mirandas, because that's what the case is asked for. Yet he walks in there with this glowing review from someone who, a fellow law enforcement officer, who gives a glowing review as to the intellectual and emotional capabilities of Derek. Just 20 minutes, 30 minutes before he walks into the room to talk to him on this. What do we do with that?
First of all, Your Honor, I think that the word brilliant was never used, but I do agree and concede that when Jose Rosa, it says he is a straight A student, Detective Elosegui took it for exactly that. He is a straight A student. Should he have delved a little further? I think he should have, but he didn't. And the fact is that statement's there. He said it, it's not true, and he took it for face value. When you look at the totality of the circumstances and you look at the fact that there were other individuals there, and in fact, there were other individuals there that were being questioned, for example, by Detective Mahela, right before the interview happened, there were more opportunities to gain a meaningful background on this child by somebody that actually lived with this child and was actually there that night. So I think that there were other tools that could have been used that weren't, in order to just gauge background, not just almost 9 minutes of an
I'm
interview.
sorry to take you out of your
Sure.
training.
So I'll say one quick thing on this point.
Sure.
Looking at the totality of the circumstances, you keep saying the dad had a morning review of his son. I mean, what else is the dad going to do? I mean, his son is potentially being accused. The cops are speaking to him. I think that you also have to factor that into what Mr. Jose Ramos was saying about his son, and the detective should consider that as well.
Yeah, and it's a shocking kind of circumstance too. And the dad very clearly said, I cannot conceive of this happening
So
with this child. He said, no psychological problems, down to earth, respectful, very independent, mature, respectful again, several times.
but he also said mature. When he said mature, he said mature for his age. I think that's what he said in the first interview. He said mature for his age. He knows how to do things that a 13-year-old can do, maybe.
Which again, I would submit that there should have been a red flag when he's asking, when Alosei Gonzalez is asking him to initial, and he says he doesn't have initials. Or when they are saying, give me your full name, and he asks middle name too, of course, your full
Or
name.
his address and telephone number.
I mean, a 7-year-old, my child knows his phone number, knows where he lives, his street name, 1,000%, what school he goes to. He knew what school he went to. He knew that. There were just certain things that he just did not know that I think should have raised a flag to these seasoned detectives.
So why do you believe it did not?
I'm sorry?
Why do you believe it did not?
Because first of all, he said, Detective Elosegui multiple times testified that he did not think that there was anything wrong with that. He said it back in December. He said yesterday that he still believed that he understood what he was being asked and that there was nothing wrong with him not knowing to him.
I don't want to take you out of your pattern. There's some specific things I want to talk to you about this and the focus that I think the cases require, but I don't want to take you off of the pattern that you want to use. So
I think
sit tight.
speaking on the obedience that he exhibited, compliance, he was very obedient, he was very compliant. He yesed his way through since 11:30. In fact, when he was on the phone with the 911 call operator, Your Honor, the police first arrived on scene at 11:36 p.m. I would submit to Your Honor that those 5 minutes before his takedown are extremely important because that could have really ended even more tragically than what we have before us. They didn't go inside. They didn't know when to go inside. He's screaming, should I go outside? They're opening the door. There's a lot of confusion there. And my point, and what I'm trying to highlight is the fact of how obedient he was, how compliant he was. Now, and as a point of reference, I'm talking between 11:36 p.m. when they first arrived and 11:49. We could look at Santos Concha's BWC for the takedown at 11:49. Now, the traumatic event that took place, it's undeniable that death is traumatic, whichever way, I'm not going to repeat what I said yesterday, but whichever way you look at it, whatever theory of this case you have, he had undergone a traumatic event. The amount of police presence, I submit to Your Honor, Detective Rico's RICO BWCs, Moya, MOYA BWC, which is in evidence, Acosta's BWC, we could see the amount of police presence. And he's witnessing this police presence and everything they're doing from Gutierrez's cop car since 11:52 p.m., 53 p.m., when he's placed inside of it. He's watching all of this unfold. The amount of time that he spent in the car from 11:54 p.m. until roughly 2:18 a.m. I submit to Your Honor to Detective Gutierrez's BWC. It's lengthy, but it's very, very telling, especially his second BWC. When we look at everything that happened from when he left the headquarters in Hialeah to when he got to the JAC. And I'll highlight some of those timestamps a little bit further. In terms of the interview, the detectives being armed, the detectives being significantly bigger than him. And when I say bigger, I mean height, weight, the fact that obviously he wasn't allowed to leave. I don't think it's in dispute that he was in custody. The fact that he's offered candy and Taco Bell after the fact, I would submit to the court as perhaps a reward. And maybe that wasn't the intention. Maybe that wasn't the intention of the detectives, but it's, yes, sir. I see you looking.
I'm just puzzled
Okay.
because how is it considered an award when it's not mentioned beforehand? In terms of a coercive nature, it'd be like, hey, if you talk to us, you get some Taco Bell. That could be construed as coercive. But as I gathered from what I saw, it was, hey, you hungry? After he had given the statement.
Your Honor, if we
How do I
listen,
look at that as coercive
if we
if it's
listen.
not mentioned until after?
If we listen to Detective Elosegui's BWC specifically about 3:06 a.m., the manner in which Detective Gonzalez mentions the candy indicates that Derek knew there was candy there. Derek had never been at that station. That was his first time at any station. He had not ever had any interaction with law enforcement, certainly not at headquarters. I didn't know there was a bowl of Jolly Ranchers at headquarters. Apparently, there is. And the manner, if we, again, the body camera speaks for itself. And I would direct Your Honor to 3:05, 3:06 in the morning and listen to what Detective Gonzalez says.
I'm sorry, ma'am. You're suggesting that there's evidence that your client confessed so he could have a Jolly Rancher. And I just don't see it from this evidence.
I'm suggesting that he's a kid like candy. And I'm also suggesting that in the totality of the circumstances, although a nice gesture, it was an unnecessary gesture. And I'm suggesting that the body camera speaks for itself. The entire time pre-interview, during the 911 call, I would submit during the interview at headquarters and after the interview, he was suicidal. Your Honor talks about the Baker Act and that process. I submit that Officer Gutierrez's BWC, the second one, specifically starting at about 5:40 a.m. There are two individuals that are interacting. It's a male and a female at the JAC. And there's a conversation that happens behind closed doors between the female and Derek. We don't have access to that. We have no idea what happened, but what we do know is that when she takes him out of that cell, she says he needs to go to the crisis center. I think the elephant in the room is he's suicidal at 11:31, he's suicidal at 5:40.
No, ma'am, I don't have an indication he's suicidal at 5:40. You don't have that person coming into court to testify. You don't have the substance of that conversation and an abundance of caution. And I actually, based upon the circumstances shown in this case, I think it's an appropriate move to take him to a crisis center because he's been through a traumatic event. He's expressed suicidal ideations early on in the evening, but did not follow through and doesn't show any indications thereafter. But it does make sense to send him to a crisis center, particularly in light of his age. But please, you cannot tell me that conversation at 5:40, he threatened suicide when you don't have anybody presented as a witness who's in that room. I'm not ready to make that jump.
Judge, at 6:10:30, Gutierrez's second BWC, the male officer says he is going to the crisis center. At 6:10:50, Gutierrez asks why. And at 6:10:51, the officer says, because he tried to kill himself. Again, I submit to the court that the Detective Gutierrez's BWC, the second BWC, is extremely important, additionally, let me say, Detective Gutierrez, this was his first time Baker acting someone. He had no idea. If you look at that BWC, he's on the phone with his supervisor the entire time. He's crumpling papers that he is filling out, throwing them away because he doesn't know what he is doing. He's being guided on what to do the entire time. He later admits at deposition that he had never done this. When he gets to the crisis center, in fact, if we listen to his BWC, which again, it is so important, he says to his supervisor, no, they will not take him. They need to Baker Act him. So there's still, when I say they, perhaps ignorance is, he didn't know any better. It's not his fault, but he genuinely was trying to prevent Derek from going into the crisis center because he thought where he needed to be was at the jail because that's what he was instructed to do. He had only been on the force for months at that point, and he honestly, he didn't know what to do. He was being guided on what to do, not only by the JAC staff, but also by his supervisor, and that's evident on the BWC. We could see his screen, his phone screen on the BWC of who he's talking to. He admits who he's talking to. He, in fact, fills out the form wrong with the parental information wrong. I think all of this is relevant, specifically to his state of mind around between 2:39 a.m. and 3 a.m. on the 13th. There was no toxicology performed, Your Honor, on Derek. There was no knowledge of how much he had slept the night prior. I mean, we know that he was in the cop car for almost 2.5 hours, but we don't know what happened the night before. I think that the fact that he's told that if he wanted a chance to explain himself and speak to the officers, the only way that he would be able to do it would be then. I think that's highly suggestive. And we know that to not be true because he could have spoken to the officers at any time if he wanted, and they'd take a statement with his attorney, with his father. That was not the only time that a suspect or a defendant is allowed to give a statement to law enforcement. And it happens all the time that suspects give statements with their attorneys present.
Really?
I think, yes.
I'm sorry because I keep hearing that, and I'm kind of wondering if you would have walked into that room at 2:49 and said, "Go ahead, Derek, just tell him about how you killed your mom," whether you as a lawyer would have said, "Yeah, let's waive your rights right now, 3 hours after this, and you go ahead and tell him." Because I've been around this building 45 years, and the only time I ever see that is on a 3.850 ineffective assistance of counsel motion. So I find it very difficult to believe it. And I don't know that it's coercive. I think your point is that by telling him the only time we can talk to you is without a lawyer would be now, you urge that that's coercive.
To him, Your Honor.
Right, to him. In reality, that's the only way it's going to happen. Okay, but is it coercive to him? But then I have to look at that statement in the face of everything else that's going on. Sorry to take a digression there, but
then just to address a couple of specifically, actually, before I address Mr. Borsch's couple of his comments, the fact that he understood and he said yes to every single line of, when I say line, the 6 paragraphs that are in that form. I would point, Your Honor, to paragraphs, specifically 3, paragraphs 4, and paragraphs 5, when there is no verbal acknowledgement. There is a nodding of his head. There's no question, there's no explicit acceptance or acknowledgement by Derek that he is understanding what he is reading. Now, in terms of, Mr. Borsch said that he was made to feel comfortable in the back seat of the police car. First of all, Detective Elosegui could not even testify whether he was cuffed or not. I would go back to the BWC. Gutierrez's BWC, extremely, extremely important. He's nodding out. I mean, he's falling asleep. I don't know. I think it's speculative to say that he's calm because he's not screaming or kicking the window. I think that it's speculative to say that he's reflecting when you could see that he's nodding out and falling asleep. Now, when he's asked, "How are you?" And he responds, "I'm good." And this is where it would have been great if Dr. Sperry would have been here, because there's a saying, which I'm not going to repeat the first word, but it would have been great for her to tell before, how most people answer when you ask them, "How are you doing?" And they say, "I'm fine." And there's a saying in psychology of what FINE really stands for. There's few individuals that tell you, "I'm actually having a mental breakdown right now as we speak." No one says that. Everybody says, "I'm good. I'm fine." Now, in terms of open-ended questions, I would submit to Your Honor, Elosegui's BWC speaks for itself. They are not open-ended questions, specifically those paragraphs that I just highlighted. The Baker Act, I think that I submit that Mr. Borsch's characterization of how it happened is inaccurate. And again, that this wasn't done in the abundance of caution. This was done because of his current mental state, which was assessed at the JAC. And if we look at Gutierrez's BWC, I think that's the best evidence of that. In terms of him inviting the police, sure. It should not have been a surprise to him that police were coming. But there's absolutely no indication that he would have inferred because they're here, I'm going to be questioned. He had no prior experience with law enforcement, zero. In terms of autism being a social and not a cognitive disability, I think that, first of all, if we look at Sperry's deposition from November 19th, specifically page 50, she explains how autistic individuals have a sense of a grandeur of intelligence, and others perceive them to be more intelligent than they actually are. That's only because they have specific knowledge on, for example, xenomorphs, or they have specific knowledge on things that other people do not. They appear to have a higher intellect than others, when that's in fact not the case. Mr. Scalzo can address the case law, Your Honor, but I would just briefly submit that, first of all, as under Ramirez, no question of custody, and looking at the totality of the circumstances, the waiver fails for all of the reasons that I just stated. Now, I agree that the case law supports that a 13-year-old can waive, but I think that based on what was presented here, this particular 13-year-old did not have the ability to intelligently and knowingly waive, and thus not voluntary. I think that Mr. Borges doesn't want to agree that, I guess, the altered standard or heightened standard in BNP and JG, but I think that we do have to scrutinize these type of scenarios with these younger individuals because they are not, and they don't reason the same as an adult. Their experiences are not the same. Obviously, age is not the same. Intelligence is not the same. And then when you have an individual that has specific, I don't want to say intelligence, I'm going to say knowledge, specific knowledge on certain things, but then is really immature when it comes to basic things that most people his age and even younger would know, then I think that that should be scrutinized with a heightened standard or greater standard. And I'll leave it to Ms. Descalzo if she wants to add anything. Thank you, Your Honor.
Your Honor, the only thing I want to add is that the cases that that Your Honor stated he was focused on, which is BME v. State and JG v. State, and which arises from Colorado v. Connolly, at least BMB and JP, those two cases specifically state that part of the reason that the interview and the waiver was not voluntary, or why the interview was coercive, is because parents were not contacted when the Miranda rights were read, and that the juveniles were taken into rooms to be interviewed or to the police station to be interviewed. And that, that is a significant factor that the court should consider, that a parent was not contacted.
But in JG, wasn't the godmother present? Isn't that the one where the godmother got together with the detective and raised a ruse that there was evidence implicating the defendant and there actually wasn't? Let me
I think in JG, I think that you're right about JG, that there was something.
I can see that that's what moved them, because they go back to Colorado versus Connolly. And really what I'm hoping the defense, I'm asking the defense to focus on is this. Yeah, nobody's going to draw a bright line and say, oh, you can take a confession from someone 15, but not 14. Or you can do it at age 10, but you can't do it at age 10, but you can do it at age 30. Nobody's going to do that. You have to look at the specifics of the interaction and the capabilities. Now, the parent being present is, to me, a big factor, and it was, I bet, to Judge Altenburg as well in BMB. But I'm looking for what was coercive. How did the officers take advantage of what you argue is a diminished capacity or comprehension of this young man.
Mhm.
Because that's what Colorado versus Connolly talks about.
Right.
Because there you had someone who was psychotic and the voices in his head
Mhm.
were telling him to confess to the police. And the Colorado Supreme Court said, well, that's not clear and convincing evidence of voluntariness. And the United States Supreme Court told them, no, we don't do clear and convincing. We do a preponderance of the evidence, and we don't actually go inside the head as to why they're doing it. We go in, we take a look at, is there a condition that made them more susceptible? And did the police officers in an improper fashion use that in a means of coercion to get the person to talk? And that's what I'm looking for. Isn't that what I'm supposed to be looking for here?
Yes, Your Honor, but Colorado v. Connolly was different because the defendant in that case just walked up to police, started talking and confessing. And he then went back to the police station and again, continued to talk. I believe that that's what happened in that case. And here it's a little different because you have, and I don't see any indication when I read Colorado v. Connolly that the defendant in that case was a juvenile, but here you have a juvenile, a minor who has done something or is accused of doing something, is driven to a police station, 2.5 hours later is brought into a room. And you know, just the fact that he's there by himself in the patrol car this whole time, you know, the 911 call tells him, no, you can't answer the call when your stepfather, you can't talk to him. You can only talk to me. I think all of those things, and I'll submit that minors who have never been in trouble with the law, I think that they are compliant when they're given orders. Right? They're taught to be compliant when adults are telling them to do something, especially someone in law enforcement. And I think that when you look at everything involved, that was the coercion. I'm not saying that the detective did something wrong. I'm not saying the detective said, oh, I'm going to give you a Jolly Rancher if you confess. No, I think it was everything that happened and led to him being in that room is what was the coercion. It wasn't including not calling the parent, knowing that the parent was available, right? And the parent was asking about his son. And the detective says that. And we hear it when on the Jose Ramos interview, he's asking about his son constantly, and they're not letting them talk. And you know what, Your Honor? Maybe no lawyer would allow their client to talk in one of those rooms, but a lot of parents consent to allowing their children to speak to law enforcement.
Ain't it? Oh, absolutely. It comes up in the cases all the time, and I had it in cases in juvenile court. No question.
So I think that was the coercive nature, knowing that there was an adult present, having this kid with them for hours, and not, you know, giving him the choice. Hey, do you want to talk to your dad? Your dad's outside. Or
what do you make of the fact that, I mean, what do I do with the fact that his father's engaged in law enforcement, knew that the police officers had received information that his son had committed an assault, and they were not yet done with their investigation, and he knows his son's right there, and most law enforcement officers would know the next step is they're taking him down to the station and maybe to the jail, yet there was no request that by a parent to have an opportunity to speak with Derek before the police officers were finished with him.
So
What do I make of that?
So I think there's a misconception because I kept hearing the word law enforcement thrown around yesterday as to the father. And the father is a TSA agent. I'm not sure that's the equivalent of law enforcement as a detective.
I'm sorry, I gathered that it was for Customs, United States Customs, not TSA.
I'm sorry, Customs. I apologize.
You can ask him, that's a world of difference.
You're right. It is a world of difference. But I think U.S. Customs working at the airport is not the same as a detective investigating. I think it's very different. Okay. And I think that what they're taught and the tools that they're given, I mean, maybe not today, but at least at this point was very different. And I believe that the father was continuously asking, where's my son? I don't believe at any point they said, we're taking him down to the station. As a matter of fact, Ramos is there for hours until 6 o'clock in the morning waiting. I'm sorry, I said Ramos. I meant Rosa. Mr. Rosa is there until 6 o'clock in the morning waiting to see, you know, what's going to happen with his son, and nobody's telling him anything. So and he is asking, Your Honor. So I'm not sure, what was he supposed to do? Say, no, you can't talk to my son, or bring him back, or demanding? I think he was doing that in the most respectful way. And also let's put into the equation, I'm sure you've watched the videos by now, that Mr. Rosa was extremely emotional and in shock learning about the events, and then learning that Derek's mother had died. I mean, he was,
I don't think he learned during that interview that she was passed.
but she was
During
stabbed.
the video in the patrol car.
Right. In the patrol car, I think he learns that she was stabbed and he starts crying.
And asked how many times, and the detective was not clear with him in his response.
Right. And so, you know, I think that you have to factor that into the equation too, that the police officer, that you have a father asking for his son, asking to speak to him, asking to interject, and they're saying, no, not now, not now. And maybe.
Sorry, wait a minute. Say that again.
I said, you have a father asking about his son and asking to speak to
I
his son.
have evidence of him asking to speak with him.
I think it's on the video, Your Honor.
I don't believe it is, ma'am. I can go over my notes because I
¿En serio?
very recently reviewed it.
Miren esto.
I can give you, he does speak to him, not to, let's say, he does ask.
You need to give me a timestamp on that because I just listened to this last night and I didn't say, and I did not see any indication that he requested an opportunity to speak with his son.
He did, Your Honor, and I'm sure if I look through my notes from
Can
yesterday.
you give me a timestamp right now? I need to look at it right now because that's a factor in this case. And I, from what I recall, I cannot give you that factual benefit.
¿Y por qué no habla la fiscalía ahora?
We're gonna look for that timestamp.
Uh-huh.
I'll listen to any more questions, Your Honor. I think I'm gonna sit down.
I guess I could ask you as well. I don't find any place in Dr. Sperry's depositions where she actually renders an opinion that the defendant did not understand his Miranda rights.
Oh, that's a good point.
Is there some place in there where she does render that opinion?
It's not specific, Your Honor, but she does discuss his capability to waive Miranda and whether he can do it, given his diagnosis, and it's in the December 19th deposition. And it's at pages 30 and 31, 37, and 42 and 43. And then 138 and 140.
Okay. Is there any particular reason that you can think of that the doctor failed to utilize the normal manner, the normal evaluative tools for Miranda comprehension?
I believe that has to do with the task she was hired to do, but I would have to ask Ms. Rillo.
Well, she knew she was going to talk to him about his ability to understand Miranda, correct?
Yeah, Your Honor, and I would attribute that to, again, timing. When I say timing, I mean trying to accomplish everything that we try to accomplish in this case, in a matter of time that we have. She's not local, Colorado. She refused, I always say confused, but she was really against doing video conferencing with Derek. And she wanted to do everything in person. The reason why she's going to go back and follow up in a timely manner, when I say timely manner, before her deposition on November 19th, is because she had just left Florida less than a month before for the purposes of Derek.
Ma'am, she didn't even know some of the diagnostic tools that are used for Miranda. There was a very clear section of cross-examination during her, or examination during her deposition in the second one, where Mr. Borst went over clearly the normal tests that are utilized to determine comprehension of Miranda. And some of them she was aware of, but didn't even bother to address or administer. And one or two she was not aware of. Further, she didn't even ask him what he said to the police. She didn't even ask him, what did the police say to you? How did you feel? What were you thinking? What was going on in that room when you said, sure, I'll talk to you, and you signed these documents? And as long as we're talking about this, because this was very disturbing, it appeared that if at least some part of her responsibility was to determine his ability to waive Miranda rights, that she hadn't even viewed the video to its conclusion. When she did indicate that she'd been provided the video, a body-worn camera of the confession that we saw yesterday, and she was asked, do you recall? She said she had it, maybe she'd watched it once. And she was asked, do you recall the portion where Derek asserted his right to terminate the interview, to have an attorney. And she said, no, I don't recall that. So jumping to the end, how am I to accept, can you make an argument that I can take her depositions and draw from there a scientifically reliable opinion under the standards I have to look at under 90.703?
I think, let me break that down. So that was a lot. So
Yeah, it is. But at the end of the day, I have to make a decision as to whether there's an opinion from this doctor with regard to Miranda warnings. And I have to look at whether she followed a reliable scientific methodology. So I need for you to identify for me, if you can, and I don't think it's there, which is why I ask.
I would agree that the information is not there in order for us to rely scientifically on her opinion on that aspect. But going back to your Honor's question, which is, first of all, why did she not do it? I will go back to timing. The fact that she didn't know about certain tools that are utilized to do it, that's a different question. And that goes directly to her.
Yeah.
I'm not going to speak for her on that. But why didn't she do the second part, meaning evaluating whether that interview was, in her professional opinion, inherently coercive, or he did not actually waive his Miranda rights? That has to do with timing. She is somebody that is extremely thorough, and her first order of business was establishing a diagnosis and confirming it. That's what she wanted to do. She told us that from the beginning. Again, the fact that she doesn't live locally, the fact that she had just left Florida for the purposes of this child less than a month before, has a lot to do with that.
¿El juez fiscal o el juez?
Okay. Anything else from either side?
Nothing further from the defense, Joe.
All righty.
¿Este juez está actuando como
I need
fiscal?
to put my notes in order. Can we take a quick 5 minutes and then I'll give you determination on this?
All right.
Vamos a esperar 5 minutos. Oye, pero ¿qué cosa es esto, men? Este juez está actuando como si fuera fiscal. Yo de verdad me quedo sin palabras. Mira cómo se ríe Jonathan y demás, porque en la realidad el juez se la está dando toda. Es decir, para él, la psicóloga, fíjate, es más problema que la policía de Miami, de la policía de Hialeah. Fíjate, la policía de Hialeah ha hecho cualquier cantidad de barbaridades y él ni ha hablado de la policía de Hialeah. Yo me quedo sin palabras. Ha cuestionado más el tema de la psicóloga que la misma policía. Vaya, increíble. Es insólito lo que se está viendo en este caso. Insólito. Insólito, ¿verdad? Wow. Insólito, ¿verdad? Me quedo sin palabras, caballero. Las cosas que se están viendo en este caso. Son 5 minutos, caballero. En 5 minutos volvemos. Pero realmente está fuerte. La fiscalía puede hablar lo que le dé la gana, la policía puede hacer lo que le dé la gana. La defensa es la que más cuestiona al juez. Déjame ponerte un momentico algo aquí, que ya le puse la traducción del día de ayer. Quiero ponerte el video de ayer con la traducción para que te des cuenta la complicidad entre la policía y los jueces, que diga a los fiscales, vamos para allá. Miren esto. Este fue el video de ayer. Este fue el video de ayer. Ahí es cuando llegan a Dere, ahí está González esperando. Ahí lo entran.
Thank you, everybody. Please be seated.
Bueno, ya empezó ya esta historia.
Okay.
Sí, hoy la definición final, según
All
comentan
right,
hoy.
we're back on the record in state of Florida versus Derek Rosa, F23-21321. The record reflect the presence of the defendant, having heard the evidence from yesterday and all presentation from both sides. I'm ready to rule on the defendant's motion to suppress his statements. And I have to tell you, I'm going to deny this motion. Let me go ahead and set some of the standards and some of the factual findings that I would make on this. First, it's a preponderance of the evidence standard that the state needs to show the voluntary, knowing, intelligent waiver of Miranda rights. The preponderance standard is 50%. As the other Judge Hirsch would say, it's 50% plus a feather is what carries the day on the greater weight of the evidence. I take into consideration a number of factors here, and I think the cases that we're looking at, I have no question but that this young man was in custody under the Ramirez standards. And then we are asked to look at least 5 factors that are considered significant on the totality of the circumstances. We'll take you to where those are. The first is I looked at the condition, or I think the way it is described in Ramirez, Miranda, and Herrera is the suspect's age, experience, background, and intelligence. I noticed in a lot of the cases with the younger people that there had been previous experience with law enforcement where they had previously been given Miranda warnings. That's not the case here. Also, we have a young man who's 13 years of age. He is autistic. I do accept Dr. Sperry's diagnosis that he would be autism 1 on that spectrum with no intellectual disability. I have reviewed the school records. I do believe he's intelligent. I do believe that Jose Rosa had an advantage of knowing his son well and described him as very intelligent and respectful. And I think that because of the age, the officers should have been on and were on notice that they needed to be careful. And I'm going to get to that in just a minute. With regard to the autism and ADHD diagnosis, I accept Dr. Sperry's opinion with regard to autism, but I do not find an opinion from her with any scientific reliability when it comes to any assertion that the defendant's autism played a part in his ability to understand, comprehend, and waive his Miranda warnings. And I do that because she didn't even talk to him about that, whether it's time constraints or otherwise. I just can't get an opinion. Further, it is standard, and I learned this from the defense provision of fundamentals of forensic practice in chapter 5, talking about Miranda and the specialized Miranda measurements, specialized evaluative tools that are used. The Wechsler IQ test, the Flesch-Kincaid readability test, the Gudgeon-Sun suggestibility scale, the wide range administrative test, the MRCI, all of these that are used by forensic psychologists all the time to determine somebody's capacity to understand and weigh Miranda were not even addressed by Dr. Sperry. So I can't find anything from any opinion that his autism played some role in this. Let me go back to the 5 standards. It is, on the whole, I don't find evidence in this record that Derek Rosa was not sufficiently intelligent or comprehend or had an inability to comprehend his Miranda warnings due to age, maturity, intelligence, or his autism and ADHD. And I'm going to make a further finding later that the officers took special care to that, and I'll talk about that how in just a minute. Now, the fact that his parents were not there, one having just been deceased, sorry, that's my boss calling, there was, and I got to tell you, neither of you mentioned it, but isn't it like lawyers? The lawyer can show up at the station house and they don't have to let him in, but that the defendant or the child has to make the specific request for the parent. And my recollection of the case law is that the child has to not only say, gee, I'd like to see my dad. It has to be, I don't want to talk to you unless my dad is here. And we have nowhere near that type of evidence in this case. So while in terms of whether there may be coercive factors, I would take the lack of parents into consideration. The fact that the parent was not there is not dispositive of this matter. He was in the station house. I candidly, and I'll make a finding, I don't find that his retention in the police car was coercive. I think there was a lot going on that the police had to deal with in the early hours, trying to figure out what they've got, what to do next. And I don't think they delayed it or delayed the process or in any deliberative fashion kept him from that interview room in a manner to be coercive. I mean, y'all have been in this courthouse for a while. How many times have we seen people stuffed in an ice box for 4 hours before they ever take them out to the interview room? I see those smiles over there. Yeah, that seems to be the standard procedure. That was not done here. I don't find any fault in the amount of time that he was before he was kept and taken into the interview room. There is a large factor here is that there is a written waiver. I think that was a big factor in BMB, the second district case, where Judge Altenburn found the statement to be involuntary. And in that particular circumstance, the detective turned off the recording device when it came time to administer Miranda warnings and obtain a Miranda waiver. And I think that probably disturbed the second district judges considerably. That's not what happened here. Here it's all done on video. The written waiver is presented and is confirmed in the file. And I'm going to deal with the manner in which the Mirandas were administered because Detective Elasogi certainly deserves recognition that what he did in grabbing that form and extending the analysis or the explanation to Derek made a huge difference. If it had simply been Detective Gonzalez reading the rights and then saying, hey, here's the form, sign it, we'd have a much, much, much closer case here. But by taking that form and then going over each right specifically, having Derek read the right out loud, acknowledge either by out loud with a yes or a head nod, or an acknowledgement that his signature, placing his name on there, for the first 2 or 3 or 4 was an acknowledgement that he understood. I don't know why it would not be such an acknowledgement for number 5 and 6. The suggestions to the contrary just don't seem to hold water. But I think the detective took the appropriate measures to make sure that Derek comprehended the Miranda warnings and gave an effective waiver. I don't find anything in the manner in which they addressed questions or presented questions which were coercive or demanding that he respond, or colors this factual finding that it was a knowing and intelligent waiver of his rights. And of course, the one thing that does speak volumes is that when he came to something that he did not want to talk about, Derek Rosa terminated the interview. He was asked if he wanted to terminate the interview, and he did. So I'm sure I've missed something here with regard to factual findings. Let me check real quick to make sure there isn't something that I need to make a finding on. So give me a moment.
Ahora lo sé y necesito un reconocimiento. Increíble, pero increíble. Vaya, yo no sé.
Okay. I think I've made the factual findings. The only thing I would supplement is my determination as to the intelligence and ability to comprehend is also based upon a review of the school records as well as the other materials contained in the record. That's my ruling on the motion to suppress. I'd like to, if it's okay with you guys now, address your motion to continue the trial and further proceedings. I've heard your arguments yesterday with regard to everything but the new revelation, which I'm going to get into in just a moment. I don't find good cause. The case has been properly, and let me be clear, lest there be any question, against the backdrop of this. We started this case in October of 2023. In December, it came to issue as to whether the detention of Derek Rosa was appropriate in an adult facility. We conducted, I think, 2 days of hearing, somewhere around 12 to 15 hours of testimony regarding the circumstances of his detention as a 13-year-old in the adult facility. And while it did not violate the Eighth Amendment to the Constitution, it was constitutionally sufficient, it's certainly not optimum. And I think it was made clear 2 years ago that this was not going to be a case where Derek Rosa spent all of his teen years sitting in an adult jail waiting for his trial to come about. It didn't seem fair to him, and it didn't seem like it was the right thing to do. And unlike the tendency in this courthouse to take 5 to 7 to 10 years to bring a first-degree murder to trial, it was agreed that that would not be the case here. And as a result, Ms. Riello and Ms. Medina did, and the state in the provision of their discovery, did an exemplary job in preparing this case for a trial. And we came to a September trial setting. And at that time, the defense indicated they were not ready and that Mr. Baez was distracted with other matters going on, the specifics of which I'm not going to get into by his request. So we took the case off the docket in September, and I asked the lawyers to select the dates that you wanted to try this case. And we ended up with the January dates, the dates we have right now. Mr. Baez removed himself from this case back in this third week, I think, of November for the very same reasons that a continuance was engendered back in August. And it's been some 8, 6, 7, 8 weeks since then. Ms. Gonzalo, you came in, came in to this courtroom on the 17th of December, and I think it was, or 16th. And we're welcome to come on this case, but with a very clear message that this case would be tried in January. Okay, because, and when we get to this function of you've come in this case, well, yeah, but there's 2 fine lawyers been on this case for 2 years and have prepared this case. What I'm not hearing is the state has amended the charges. That would engender a continuance. There's some evidence that has just been turned over. That would engender a continuance. I'm not hearing that. There's a lawyer who's been the only person responsible for representing the defendant. He or she just disappeared. We got brand new counsel. That's not the case here. And when you spoke yesterday about you wanted to investigate, my question was, investigate what? The investigation and preparation in this case is done. It's a question of you coming up to speed to be trial counsel. Now, with regard to the matters that were brought to this court's attention yesterday, I need to ask some factual questions that I would do at sidebar before I speak further about that. Is that okay with you guys?
Yes.
Come sidebar.
Ahí van a deliberar. Lo mismo de la vez pasada. Bueno, ya esto va a terminar ya. Nada, caballero, se sabía. Se sabía. Ese señor lamentablemente está haciendo papel de fiscalía. Él lo iba a negar todo. Obligatoriamente ahora hay que apelar a esto. Hay que apelar a esta decisión porque realmente esto, caballero, esto es un desastre en todos los sentidos. Esto es un desastre. Ya el Jonathan lo sabía. No sé si tú viste cuando se hizo el receso de los 5 minutos que él salió riéndose y diciéndole algo a la otra. Es decir, ya ellos lo sabían. Ellos sabían lo que venía detrás de todo esto. A mí lo que me llama la atención es cómo él dice que a Elosegui hay que darle un reconocimiento. Entonces, ahí es donde tú te quedas así. Tú dices, ¿reconocimiento por qué? ¿Y para qué? Reconocimiento puede ser que sea por esto, ¿no? A ver, puede ser por esto, ¿no? Un reconocimiento por esto y cómo González estaba mirando los seis como diciéndole, ¿y a ti qué te pasa? ¿Eh?
This little dot right
Por
here.
esto.
Aloud,
Yes.
before we ask you any questions, you must understand your rights.
Okay, you understand that?
Yeah.
Okay. Go ahead and initial this little dot for me. It means that you understand that. Yeah, just your initials.
I don't have initials. I just have my name.
Okay, whatever, right here.
¿Ve? Mira como el detective mira, como diciendo, ¿y tú qué estás haciendo? En varias ocasiones mira a la fiscal y lo mira a él como diciendo, ¿ustedes qué están haciendo? Pero también puede ser que sea un reconocimiento. Puede ser, ¿no? Nadie sabe. Por esto también.
Thank you.
Ahí pensó que le apagó la cámara.
So, on, Joe?
No, it went off.
You went off?
¿Ok? Ahí ya me fui. Ya apagué.
Okay.
Do I get the
Let's, get ID. We're gonna go ahead and swab them, take the clothes, and everything now, okay?
¿Entendiste? Es decir, el detective estaba en contra totalmente de lo que hizo Elosegui. En contra totalmente. Si tú te das cuenta, pero vamos a seguir porque ahora se pone bueno. Porque están hablando de ediciones y que yo sepa, tú no puedes editar nada. Estás hablando de inventa. ¿No es verdad? Entonces, a ver, puede ser que sea un reconocimiento por eso. Vamos a seguir. Escuchen.
No, you can stay there. You can stay there. Whoever's new at this, I wanted for him to get more detail.
Ok, está hablando lejos del otro detective porque él dice que el otro detective era un novato y él necesitaba mucho más detalle. Pero escucha.
Rather than the bullshit questions before, you know?
Yeah.
Ok.
But no, yeah, thank God. Because, you know, you start going into, I usually go right into the meat and potatoes of it, you know?
Yeah.
And did that and then go back.
Como diciendo, lo que estaba haciendo él no servía. Tú sabes que yo voy directo al grano. Tú sabes que lo mío es otra historia. Esto de estar dándole vuelta, no sé qué más, a mí eso no me interesa. ¿Y qué dice la fiscal? Sí, yo sé. Es decir, aquí no se está hablando que estamos en presencia de un menor de edad. No. Aquí no se respetó ni papa, men. Eso vuelvo. Ayer lo dije por la noche cuando se puso el video. Mañana esto le puede pasar a tu hijo, a tu nieto, a tu hermano, a ti, a tu abuela. A cualquiera le puede pasar. A cualquiera. Pero vamos a ir.
No, but
Don't get a consent form for his DNA, did you? Well, to get a warrant, I think, at this point.
yeah, we're going to get one for that and for the phone anyway, so.
I gotta take his clothes.
Ok.
I thought I'd explain Miranda very careful to him since he's so young, you know?
He's not cuffed, is he?
No,
Yeah, there we go.
no. Yeah, we're on a time clock, 6-hour time clock.
Para que te des cuenta cómo funcionan las historias, mano. Yo, este caso, yo realmente no sé qué tú piensas. Puede ser que sea yo el que estoy, tú sabes, que veo cosas extrañas aquí, pero aquí yo veo muchas cosas extrañas. Pero muchas cosas extrañas. Vamos a repetirlo. Vamos para atrás. Yo le subí un poquitico el volumen, ¿ok? Yo le subí un poquitico el volumen. Vamos a repetir esta parte. Por ejemplo, cuando lo llevan al baño, fíjate. Vamos a ver cuando llevan al baño de él. Mira. Caballero, ustedes tienen que darse cuenta de algo. Ese muchacho, hasta ese momento, está bajo su presunción de inocencia. Ese muchacho, hasta el momento, ahora, hoy, está bajo su presunción de inocencia porque nadie estuvo en la escena del crimen. Aquí hay muchas cosas mal contadas. Aquí hay personas las cuales no se atrevieron a firmar un interrogatorio porque no están seguros de las informaciones. Es decir, aquí hay muchas cosas, muchachos, que tienen que revisar primero antes de salir a juzgar a un menor de edad en los Estados. Caballero, yo llevo más de 20 años en este país. Si tú me dices a mí que yo iba a ver esto que estoy viendo yo ahora, yo me quedo sin palabras. Porque vuelvo y te repito, le puede pasar a cualquiera. Cualquiera no está exento a que esto suceda. Esa confabulación entre policías y fiscales, caballero, eso al final trae problemas. Porque el fiscal es el Estado. El fiscal tiene que velar por los ciudadanos. El policía es otra historia. El policía es un bruto. Es otra historia. Pero el fiscal no. El fiscal es el Estado. Entonces, cuando yo veo estas cosas, yo digo, caballero, ¿en qué país yo estoy viviendo? Y ojo, no es el país. Estamos hablando del condado Miami-Dade. Porque esto yo no lo he visto. Yo he visto casos en Houston, que es donde yo vivo, y Houston es demócrata, a partirse. La mayoría de todos esos jueces son demócratas y los fiscales de Houston. Así yo nunca he visto esto. Nunca en mi vida yo he visto esto. La otra vez pusimos y debatimos un juicio que hubo en Colorado. Tampoco, no sucedió. Con Carly Gray fue diferente y esa muchacha descaradamente acabó con la vida de la madre. Y el juicio fue diferente. Y la recopilación de evidencia fueron diferentes. Es decir, hay mucha corrupción. Y lo digo y lo repito. Y a mí hay que demostrarme lo contrario, men, Por eso es que esa fiscalía está bajo un escrutinio de querer ganar a toda costa y lo estamos viendo. A mí lo que me llama la atención el juez, ese es el que me llama poderosamente la atención. ¿Ok? Que estamos hablando supuestamente de un tipo que tiene mucha experiencia y te está prestando para todo esto, man. ¿Qué hay detrás de todo esto en este caso? ¿Qué hay aquí? ¿Qué hay aquí? Vamos a poner que están ahí. Está sin audio. Yo nunca había visto una cosa igual. Realmente yo nunca he visto una cosa igual. Deja que pongan el audio. Está sin audio. Ellos saben que han
But the matters
cometido.
that were brought up yesterday that impact potential plea negotiations and potential mitigation of punishment were the defendant to be found guilty of some crime. And it's a welcome change to see that the defense and the state are actually engaging in discussions in a broader manner with regard to this case. However, there's nothing that's been presented that would prevent this case from going forward to a trial. And we have 2 weeks between now and the selection of a jury, the commencement of jury selection, and we have 2 weeks and 6 days before opening statements, assuming we can get a jury in those 4 days. And we're going to go over that process in a few minutes. But what you basically said is, we're working on a potential resolution of this case. And now that we're on the eve of trial, seems a little late to get there, but I'm glad you're working on it. I urge you to continue working if that's the right thing to do in this case. And if you come to a resolution of this case between now and January 20, let us know. And we'll act accordingly to see if it's an appropriate resolution and if it would be accepted by the court. So the motion for continuance of the trial is denied. I want to talk to you about a number of different issues that are now ripe with regard to the trial of this case and the jury selection. Make sure I've got the notes for that. Okay, the first thing that I want to address with you guys with regard to this is some of the issues that are a little bit concerning, and I need to get your input on whether it's appropriate or not. This is what is known within the judicial circles as a high profile type of case because there's press coverage all the time. And I'm informed by the judges on the second floor that when this case is in session, there's a lot of people out in the front of the building disturbing them anyway. I've not been there. I've not been a witness to it, but the other judges find that there's some somewhat loud campaigning or demonstrations on the front steps. I was shown by one judge sent me a picture of a truck circling the courthouse with Derek's picture, my picture, and the prosecutors, I think, were on there at some point or another, declaring the corruption of the Miami-Dade courts in bringing this action against Derek Rosa. Everybody is absolutely entitled to their opinion. My concern is a jury being subject to, and I use the term extrajudicial, not as extra judge, but extrajudicial in the sense of influences outside of this courtroom. And I'm concerned about the way the normal pattern is in this courthouse, the jurors show up in the parking lot across the street and walk in through that front door, and I'm concerned about them walking in through the front door through a large number of people who may be urging partisan positions in this case.
En serio.
And I need to know whether you disagree with me that it's a valid concern or not.
The state believes it's a valid concern.
Ustedes están escuchando esto, ¿no? No, esto está
I
peor
have not
todavía.
seen the people, Your Honor, so as far as today, there was no one outside, and yesterday there was no one outside. I've seen people in the courtroom. I don't know what alternative the court could propose other than the jurors walking up through the front of the building.
Yeah, I have a couple of things that I would propose
Okay.
on this. And from the what I've looked at, I think here we go. Here's what the First District Court of Appeal says about this. Judges are not free to disregard factors external to the evidence, such as the atmosphere in and around the courthouse, which may influence a jury's verdict. The Sixth Amendment imposes upon trial courts an affirmative obligation to minimize any risk of unacceptable factors affecting the accused's right to have a fair trial. Courts have an obligation to ensure that the trial is a fair and a fair process, and most certainly an obligation to protect jurors from any possibility of influence or intimidation. Now, this came up in a case where at closing argument, the prosecution loaded the gallery with uniformed police officers in what I think was a battery on a police officer case, even after the court had warned them not to wear their insignias in the courtroom. And the First District reversed the jury verdict of guilt because of that influence. There's some other cases as well. I can give you some citations if you like. And of course, Rule 2.450A recognizes my authority to control the conduct of proceedings. So here's what I'm sort of thinking. It may be easier to control the jury selection process in a different courthouse. And I'm thinking that we might want to select a jury over in the new courthouse. Okay, I'm not seeing anybody get crazy about that, but
That maybe absolutely necessary. And avoid insurers being subjected to that.
well, we have a bunch of stuff that we have to be concerned about because in order to do it in a courthouse, we have to have a secure facility for Derek Rosa. We have to have an ability to get him in and out of the courthouse without being seen by the public in jail garb or in handcuffs. And I think the new courthouse is a little bit more secure in terms of exposures to people as they come into the courthouse. They go right in through the front door up to the fourth floor and into the jury room. They've closed the street in front of the courthouse for now.
¿En serio?
Between 73 West Flagler and the new courthouse. And that would allow for a better control of people out in front. I've been there with Corporal Wims and with Captain Eber, and they have figured out a way to do all of the things that's necessary. I'm happy to do a site visit with you guys next week. Pick a day. You can do it at 8 o'clock in the morning if you like. You can do it late in the afternoon or try a lunchtime. But I think it'd be important to take a look at the physical structure to see if it works for you. Okay. Once we get a jury, my concern is a couple of things. Again, walking them into this building. I don't care to sequester a jury, but I'm inclined to, and I ask your thoughts about this suggestion, I'm inclined to have them picked up by the sheriff at a remote location and brought to this courthouse through the garage so that their entry into courtroom 4-1 is without having exposure to any extraneous circumstances. That's something y'all would address with them during jury selection as well, to make sure that it doesn't have an improper influence upon them. Let's see. in the selection, we can go over this when we're on site there, but my thought would be to bring in, we have to pre-select jurors. My thought would be we're going to bring in probably about 80 a day, Monday, Tuesday, Wednesday, probably at about 25 to 30 at a time, because we need to go over the two major issues, which are who's available to try this case for the next 3-4 weeks, or 10 plus days of evidence. And who knows who Derek Rosa is. If there are other additional preliminary questions that you want to screen the jurors with, please let me know and let's address them. But my thought would be to take 25 at a time, the ones who are perfectly fine giving us their time, don't have conflicts, and the ones that are we can establish are no, probably, and of course we have to do this through individual voir dire of knowledge of the case. The ones that pass that initial screening, we'll tell them come back Friday. And hopefully through the course of the 3 days, we end up with a panel of about 75 to come back on the Friday. And from there, we'll get about 15 jurors. And on the Friday, I'll give you as much time as you need to speak with the jurors in the selection process. It's possible it goes faster, possible we have to adjust to that. But after talking with Judge Tinkler Mendez and Della O and other people who've done these larger juries, I'm thinking that might be the best way to go forward.
Usually the Michael Menendez case, we have actually changed any case. But I'm about to say, I'm familiar with the individual voir dire, would be happy to also do the defense.
I'd like both sides to send me suggestions as to what you suggest for individual voir dire. I also need kind of an agreed factual statement to be able to tell the jury, the prospective jurors, this is what this case is about. Because we usually start that each time, you know, this is what this case is, or is there anybody here who just can't sit on this case because of the nature of the case? Okay. Let me also say that in order to expedite it, ordinarily I would bring in a panel of however many and do about 45 minutes. But the first 15, 20 minutes are why they're there, the function of a jury, the responsibilities of a jury. My intent would be to do that to the entire veneer in the main jury the main jury assembly room, like I did this morning. The jury greeting, which covers a lot of their responsibility. And I will ask the lawyers, I'll invite the lawyers, you're not required to, but I'll be talking to your jurors. You might want to have somebody in the room to make sure you know what the jurors have heard. And if there's any objection to what I say to them, to put it on the record later. Do you follow what I'm saying? I'll be giving a jury greeting to the jurors there at 8:30 so that we can make it a little bit quicker when we break it down into groups of 25 or 28. You'll need to come up with a date where we can do a jury inspection. I mean, a site inspection next week. All right. I also am going to continue on with prohibiting telephones and recording devices in the courtroom during the course of the case. We'll be trying the case in 4-1 when we get back here. So there's 120 seats in there for people to sit in. There'll be a gallery of people, but I'm not going to allow them to have phones or recording devices. I'm also not going to permit them to wear partisan attire, similar to the case that we find out of the first, called Schutz versus State, which engendered a
Pero yo creo que estoy en Cuba, man.
a reversal. There's another case out of the first from 2014 called Long versus State, where all these men came into a lewd and lascivious molestation case with their leather jackets emblazoned "Bikers Against Child Abuse." Caused that verdict to be reversed as well. So we're going to not allow partisan positions on clothing in the courtroom. All right. I need to do one or two more things, and then I think we might want to take a break before we address the King and 404 issues, which we can do today as well. Let me leave these two things on the table. We can address them later. And after our break, we can address any of these jury issues. But I ultimately need to do an Alcorn inquiry of the defendant regarding plea negotiations and any plea offers that are made. I'm going to hold that off for now. Okay. The other thing is this. There's enough in this record, I believe, for me to order sua sponte a competency determination of your client, Mr. Calso and Ms. Riello. I state that because of the extensive record regarding his autism, ADHD, and other history of misdiagnoses. And nobody picked up autism until the jail doctors got him. But there's enough there for, and you raising the competency to understand Miranda's. Oh, by the way, I totally forgot to mention Dr. Sperry going through the confidentiality questions with the defendant. You can in your briefs if you need to. But there's enough, but I don't know if I need to. And I'm talking to the lawyers, the people who are closest to the defendant. And I inquire, if you think it's appropriate, as to whether, as an officer of the court, you have any good faith belief that there's any necessity for a competency determination, any suggestion, hint, requirement. I'd rather do it now as opposed to on a 24-hour basis on January 20. So I ask counsel what your position is on whether the court should conduct competency evaluations of your client before the January 20 trial.
This is Phelps at the podium.
Okay. Yeah, but ma'am, I got to do it. In reality, you've been on this case for 2 years, and I don't need to check the jail records to know that you're the one person who's seen this young man more than anybody else from the legal field. So you would be the person who would be the best, I think, it seems, in the best position to be able to respond to that question. But I'll defer to Mr. Calso if you like.
Your Honor, I don't believe he requires a competency test at this time.
Okay. I'll defer to your positions on that. I really hope it doesn't change. Well, actually, if it changes, it changes. I really hope it doesn't change at 9 o'clock on January 20. If it changes at any time between now and January 20, that you believe competency is at issue, I'm going to urge you to let me know immediately.
Yes, Your Honor.
Okay? All
Of
right.
course.
Now, the only things I think that are left on the plate are the King issue, the 404 issue, and I still don't understand why -STR DNA.
Actually, would you like an update on that, Judge?
Sure.
So I feel like I did a poor job explaining to the court about the CODIS hit. So what I did is I reached out to the MDSO director who understands and runs the CODIS system. And so to the extent the court would need or would like to hear or have additional information about why the CODIS hit is not relevant, I could either proffer to you what he tells me, and I have a scheduled meeting with him, or I could have him speak to you live and explain to you what it means.
Let me start by saying, if he talks to me, it's in the courtroom. And
Yeah, that's what I mean.
And I want to make it very, very clear, because when we last talked about this, I bragged about my daughter being a DNA researcher in New York at the American Museum and inquired, do you all mind if I talk to her? Court counsel let me know very fast that's wrong. And they're absolutely right. For two reasons, I did not seek outside information. The first reason is you guys are entitled to hear it when I learn it, to be able to determine whether it's proper and to be able to respond to it. So partially on that, I did not seek any information from my daughter. The other reason is I'm hoping that your experts won't roll their eyes and give them one more indication of how much smarter they are than, you know how daughters are. So I just want to make that clear for the record, because I did mention that, but I have not sought outside information on the Y-STR DNA issue. One way or the other, I'm going to need to hear either from an expert or from presentation from you guys for me to fully understand that.
Judge, the CODIS administrator for MDSO is John Reddick. I had a meeting scheduled with him at 1:00 today. Obviously, I may have to move that because I'll be here, but the plan or the goal would be to make him available to the court and the defense as soon as it works for everyone's schedule.
Okay. Thank you for that. All right. Do you want to address King and the 404 issue now? I really don't think it's going to take, well, I don't know how long it's going to take, but I don't think it's going to take forever.
I would leave it to the court. I don't have a preference.
We either take a break and we'll return to it in about 45 minutes, or we could just
Can we
muster
have,
run through.
Your Honor, can I have a 2-minute restroom break and then we can take care of it? Is that
That'd be
okay?
great.
Okay.
Okay, thank you. Let's take a short break.
Yo quiero que tú me digas algo. Esto te voy a ver, yo te voy a ser sincero. Para mí, y sin que me quede nada sin, tú sabes. Muchachos, yo no vivo en Cuba. Yo vivo en los Estados Unidos. Yo me acojo a mi primera enmienda de mi libre expresión. Y bajo mi libre expresión, yo digo lo que me dé la gana. Lo único que pueden hacer es probarme que yo estoy equivocado, única y exclusivamente. Yo siempre le he dicho, ustedes me demuestran que yo estoy equivocado basado en las acciones que ustedes mismos cometen. Y yo salgo aquí y digo, familia, discúlpenme, me equivoqué. Pero lo que yo estoy mirando en el caso de Rosa desde el día 1 es irregularidades más irregularidades igual a irregularidades. Debidos procesos mal hechos, ¿no es verdad? Un juez haciendo papel de fiscal, porque yo te voy a decir una cosa, ahí lo que yo vi fue un fiscal, ahí yo no vi un juez. Que la gente se protesten afuera, eso es permitido bajo la primera enmienda de los Estados Unidos. La gente puede protestar pacíficamente, no como sucedió con Black Lives Matter. Porque con Black Lives Matter todos ellos se metieron la lengua donde no le da el sol. ¿Entiende? Al revés, se pusieron de rodillas. Aquí los poderes se han protestado decentemente y pacíficamente. Y se han puesto en un lugar donde ellos mismos dijeron, no están en la puerta. Están 100 metros prácticamente de la puerta. Y eso es constitucional. No puede limitar a que las personas hablen. No pueden hacerlo. Eso es para que tú te des cuenta lo importante que es votar. Y votar bien. Yo no vivo en Cuba, yo vivo en los Estados Unidos. La fiscalía habla con delincuentes. Y todos ustedes lo saben. Dicho por ellos mismos. Y ayer en un video que te lo voy a poner ahora mismo, mira, estaba esta mujer tratando de hablar con la fiscal o dejándole un mensaje a la fiscal. ¿Por qué ustedes no hablan de eso? Hablen de esto, mira, hablen de esto. ¿Por qué no hablan de esto? Hablen de esto. Ah, con la fiscalía sí. Ah, con el Estado sí. Bueno, entonces estamos en Cuba. Que mientras que estás con la dictadura todo está bien, estás en contra de la dictadura es un problema. Ahí está, mira. ¿Qué es lo que se estaban diciendo esas dos personas ahí? A ver, que alguien a mí me explique esto, caballero, que es que yo no entiendo. Un camión, una compañía de promoción en Miami que paga impuestos, que paga los impuestos para que cobre ese juez, cobre esa fiscal y ten toda esa gente ahí. ¿Van a prohibir también las compañías de promoción? Ya sería como que le envíen una carta a la compañía para decirle que no pueden dar. Ya esto es lo último que falta en este país. O lo último que falta por ver. Ya, yo no sé. Yo no sé cuál es lo próximo ahora mismo. Hace falta que me manden una carta ahora a mí de que no puedo hablar tampoco. Es decir, que yo como youtuber no tengo libre expresión. Libre prensa no tengo tampoco. Vaya, yo no sé. Esto está increíble, caballero. Y vuelvo y te repito lo mismo que dije ahorita. Le puede pasar a tu papá, a tu abuela, a ti, a tu hermano. pero como a ti no te importa eso, porque eres una persona a la cual no te interesa, bueno, ese es el problema. Pero vuelvo y te repito, con los años que llevo yo en este país y con el récord limpio que tengo, primera vez en mi vida que veo una cosa igual. Un juez preocupado de que las personas estén protestando afuera. ¿En serio? Un juez protestando porque hayan dentro personas con un logotipo que no es ofensivo, que es la cara de un menor de edad. ¿En serio? Que me digan a mí, yo puedo ser. Tú sabes del caso. Que yo sepa, el jurado no puede estar relacionado con el caso, que es lo que creo yo. A lo mejor las cosas cambiaron. Porque lo que tengo entendido es que tienen que buscar personas las cuales no conozcan del caso de Derek Rosa. Creo yo que así funciona, ¿no? A ver, explíquenme ahí si estoy yo mal. A lo mejor puede ser que estoy mal. Porque si no, a mí, ahora mismo estoy haciendo cambio de dirección para Miami-Dade y tienen que llamarme para yo estar ahí como jurado también. A ver, vamos a hacerlo. Si van a hacer a dedo los jurados que van a poner, entonces a mí tienen que ponerme de jurado. Yo soy ciudadano americano. No tengo récord, no tengo ningún problema. Estoy haciendo cambio de dirección mañana para Miami-Dade. Esto es una locura, caballero. ¿Ustedes han escuchado de esto? Aquí se está violando una cantidad de cosas horribles. Oye, yo no pensé ver esto. De verdad, yo no pensé en esto. Esto es algo que yo no sé. Exactamente. Es que no puede, caballero, ellos no pueden. Es que el jurado, lo que tengo entendido, el jurado tiene que estar desintoxicado del caso. No puede conocer del caso. Tiene que saber del caso. Caballero, yo he sido jurado. Mi esposa ha sido jurado aquí en Houston. Y yo he sabido del caso cuando he llegado, que me dan una planilla y yo me la tengo que estudiar. ¿Qué es esto? ¿Cuál video, Mari? ¿Cuál video quiere que ponga? Esto está mal. Esto yo lo veo mal. Mal. Debido a proceso mal hecho. Aquí se tenía que haber hecho una cantidad de cosas que no se hicieron. Esto es una locura. Esto es una locura. Déjame ver algo. El de seguridad. ¿Cuál de seguridad? Oh, el de... Oh, ok. Oh, este. Vamos allá. Ahí está. Ellos lo que parece que no se dieron cuenta que la cámara estaba grabando. Caballero, el juez es una figura pública. El juez es una figura pública. La foto del juez aparece en una campaña promocional para votar por un juez. El juez es público. Tú pagas el salario de ese juez. Es público. El juez no es una persona privada. No vivimos en un comunismo. Acaben de entender eso. Esto no es un comunismo. Lo que sucedió en esa sala va a tener consecuencias. El juez no está por encima de la Constitución de los Estados Unidos, caballero. Esto es lo que no sé lo que está sucediendo aquí. O a mí tú también me vas a decir a mí lo que tengo que decir o lo que no puedo. No, yo digo lo que me dé la gana. y tengo derecho a una retractación, está ahí también. Demuéstrame que yo estoy diciendo algo que no es y mándame un cease and desist. Así de sencillo. Tú me demuestras que yo estoy diciendo algo que no es y mándame un cease and desist. Ya más nada. Y ya yo veré qué hago con el cease and desist. Es sencillo. Así funcionan las leyes, caballero. Así funcionan. Entonces, ¿tú me vas a decir a mí que esto es normal? No, esto no es normal. No, el free speech aquí no existe. El free speech, no. Como yo estoy mirando esto, no existe. No existe. Porque aquí ya tú no puedes hablar, tú no puedes expresarte, ya tú no puedes nada. 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 Es decir, tiene que estar parcializado con el Estado. Si no te parcializas con el Estado, tienes problemas. No importa que seas un delincuente. No, eso no importa. Para el Estado eso no le importa. No les importa. Eso al Estado no le interesa. Exactamente. Es normal en una dictadura comunista. Estoy de acuerdo con ustedes. Pero lo están haciendo normal aquí. Lo están normalizando. No le están diciendo nada. ¿Cuántas veces tú has escuchado a alguien ahí poder hablar con un fiscal? Yo no puedo hablar con un fiscal. No puedo, no existe. Yo no salgo aquí diciendo que la defensa me da algún tipo de información. No, porque es incierto. A mí nadie me da ninguna información. Está fuerte, caballero, está fuerte. Está fuerte. Está muy fuerte lo que se está viendo aquí. Muy, pero muy fuerte. Es decir, los policías no cometen errores. Aquí en este caso todo está bien. Al revés, hay que darle... No, está fuerte, caballero. Caballero, esto es más de lo mismo. No sé si continuar con el live o quitarlo. A mí esto ya me ha dado flojera. No sé ustedes, pero esto me ha dado flojera porque yo vivo en los Estados Unidos, muchachos. Yo no vivo en Cuba. Yo vivo en este país hace más de 20 años. Yo nunca en mi vida había visto una cosa igual. Yo nunca en mi vida que un juez esté preocupado. Caballero, cuando la niña Jocelyn Nongaray, la que los dos venezolanos estos delincuentes pertenecientes a Maduro le quitaron la vida aquí en Houston, tú quisieras ver cómo estaban las afueras de la corte.
Okay, be seated, everybody. Before we go further, there are some very strict things that have to be done when you have a juvenile in custody. Statutorily, there's that 10-minute supervisory check, visual supervisory check. There's the requirement that they not be within sight or sound of anyone, any prisoner over the age of 18. And there's, as you know, as you guys know, a special unit over at Metro West. But one of the things that I'm informed of is they eat and provide food on a set schedule. And we are now at lunchtime for your client. Now, the Corporal Williams tells me that Derek says, I'm not hungry right now. I'm okay with it, but I'm not going to violate their scheduling unless I'm asked to do so, and you guys believe it's all right.
If your honor is asking me, because I sit in the box next to him, as I have been, I do not think that it's appropriate for him to skip lunch.
Oh, I wouldn't have him skip lunch.
I think he should eat on his regular lead time schedule.
Okie doke. See y'all in 45 minutes.
Bueno, ¿qué quieres que te diga? Lo mismo que estábamos hablando. Más de lo mismo. Lo mismo que estábamos hablando. No, fíjate. Hola Gaby, saludos. Lo mismo que estábamos hablando. El camión, caballero, el problema es del camión. Lo que ustedes tienen que entender es que el camión paga impuestos. Eso es una compañía la cual paga sus impuestos. En los Estados Unidos, cuando usted paga sus impuestos, automáticamente usted tiene derecho a hacer todas esas cosas. Así de sencillo. Que usted tenga su opinión, bueno, es tu opinión, es tu libre expresión. Déjame ver algo un momentico. Espérense. No, pensé que estaban poniendo a la familia, pero no. Parece que lo están haciendo pregrabado. Lo están pregrabando para después ponerlo. Estoy escuchando y yo solo puedo decir una cosa. Este caso ya solo queda en la mano de Dios, en la mano. Mira, yo sé que está en la mano de Dios, sí, claro, pero creo que este caso hay que empezar a enviar cartas, hay que empezar a hacer cosas fuertes, porque lamentablemente, claro, sin incitar a la violencia, ¿ok? Sin incitar a la violencia hay que empezar a hacer cosas fuertes, porque realmente lo que estamos viendo, a menos lo que yo estoy viendo, no me gusta. ¿Oíste? No me gusta. Pues bueno, nada, familia, voy a cortar la transmisión. Más tarde me conecto. Me voy a conectar un momentico más tarde, ¿ok? Pero estamos bien. Primero Dios, todas estas cosas al final van en contra del proceso, caballero. Créanme, todo esto va en contra del proceso, amén que tú lo veas como algo desfavorable, ¿no? Ahora la defensa tiene opciones para hacer otras muchas cosas más. Sí, déjame ver quién está en la corte para hacer una llamada. Espérense un momentico antes de irnos. Déjame ver quién está allá. Espérate. Espérense un momentico. Déjame ver quién está ahí. Espérate. Creo que Blue está en la corte. Espera. Así eso que se me conecte. Exacto. Sí, exacto. Caballero, ¿le pueden decir a Blue que me llame para acá? Pues parece que no tiene el teléfono en la mano. Espérese un momentico.
you plan on entering any written orders or just verbal?
Nope.
Okay.
It just did. You know what? I wonder if that's what happened.
Ok, vamos a cortar la transmisión y ahorita, un poquitico más tarde, cuando empiece todo esto de nuevo, volvemos y nos conectamos, ¿ok? Así que déjenme cortar la transmisión ahora y después continuamos. Se les quiere mucho, muchachos. Bye, 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 bye.